was to call me and let me. But otherwise,
The Code Enforcement Board meeting will come to order. Bobby, would you call the roll, please?
Mr. Weeks?
Here.
Miss Wade?
Here.
Here. Thank you, I'm sorry. Mrs. Dabbs?
Here.
Mr. Kramer?
Here.
Mr. Robinson?
Here.
Miss Norfleet?
Here.
Mrs. Tellior?
Here.
That completes your roll call, sir.
Thank you. Now we'll lead you in the Pledge of Allegiance, and Mr. Trask will lead us in a vocation first.
Our Heavenly Father, we gather together here to intend on doing good work. We seek to represent fairly and well those who have given us this task. We meet to serve the city of Tarpon Springs, to use our resources wisely and well, to represent all members of our community fairly, and to make decisions that promote the common good. We recognize our responsibility to the past and the future and the rights and needs of both individuals and our community. As trusted servants, we seek blessings on our deliberations and our efforts here today. This we pray. Amen.
Amen.
Flag is where? Back there somewhere? Back over in the corner. Okay. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Could have pulled up a picture.
It is the intention of this board to promote, protect, and improve the health, safety, and welfare of the citizens of Tarpon Springs by providing an equitable, efficient, and inexpensive method for enforcing various codes. Administrative orders of this board, codes within the city of Tarpon Springs. Any aggregated party may appeal a final administrative order of this board to the circuit court. Such appeal shall be filed within 30 days of the execution of the order to be appealed. Florida State Statute 286-0105 requires any party appealing a decision of this board to have a record of the proceedings to support that appeal. The procedure of the board is as follows. First, the city presents the witnesses' exhibits. After an alleged violator is able to, afterwards, the alleged violator is able to ask the city witnesses any specific questions regarding their testimony. Secondly, the alleged violator is allowed to make a presentation and present his or her witnesses and exhibits. Then the city can question the alleged violator's witnesses. After both parties have made testimony, both on the part of the city and on the part of the alleged violator, each party is asked to give closing arguments, first by the city and then by the alleged violator. After those three steps are taken, this board will close the public hearing portion of this case to discuss it and take appropriate action. Before we begin the public hearings, we will have all potential witnesses please stand now and be sworn in by the secretary of the board.
Anyone that's going to speak, please stand up, raise your right hand, and be sworn in. Face the clerk here.
Do you swear the testimony you're about to give is the whole truth and nothing but the truth?
I do.
Thank you. You can be seated.
At this time, if you'd please turn off all your cell phones or silence them at least, would appreciate it. First case, going by the agenda item number 12. We're skipping around a little bit because these people are here to proceed. Harry and Anna Patsalides. Patsalides. If you would come down, please.
Hold on a second to get in front of the microphone.
Mine may take a while. I don't mind waiting to let some of these other people go first. I think I'm going to need at least about an hour.
I think we're good in an hour.
Oh, okay. Fine, we'll take the next one and then we'll
Thank you.
take you later on. And number 9, 1711 Stonehaven.
Let's be seated.
Mr. Robley, could you state your full name, please?
Rob Lee Charles Munger IV.
Thank you. City?
Thank you. This is case number 19-800000462. The property address is 1711 Stonehaven Way. Listed owners, Rob Lee Charles Munger. I'm Officer Steve Gasson, City of Tarpon Springs Police Department Code Enforcement. Exhibit number 1 going before the board, actually, I guess, will establish whether or not he has any problems with the exhibits.
Say that again, please.
The photographs and exhibits.
I have no problem with the exhibits.
Oh, yes, thank you. Appreciate it.
So
Sorry.
exhibit number 1 going before the board is all the photographs. Exhibit number 2 are all my notices of violation and notice of hearings. Exhibit number 3 is administrative docs, case summary, property appraiser, and tax collector records. And an affidavit of posting and a copy of the sign is exhibit number 4. All my photographs and exhibits that were given to the violator, exact copies of what's being presented to the board. All notices were mailed to the property owner of record based on, as determined by the Pinellas County Property Appraiser and Tax Collector databases. All notice of violations and notice of hearings are sent, return receipt requested, as well as first-class mail. And Mr. Chairman, please accept all these exhibits into the record as evidence.
Bobby, when they get down to you, please.
Yes, sir.
Thank you.
The city's case started July 18th upon a neighbor complaint about the property being overgrown. There's trash and debris in front of the house, bags of garbage on the front porch, trash cans not stored properly, and there was a vehicle, motorcycle, which appeared inoperative. Since that time, I've had no contact with the owner up until today. On July 19th, the notice of violation and a notice of hearing was mailed. The reason why both steps were taken is I have had some prior calls out there for similar things, so my intent, even if it was in compliance, was to be established. As of this point in time, it's not in compliance, so it's still just an open case. July 19th of this year, we mailed the notice of violation and notice of hearing. July 22nd, there was a notice left that it was delivered. On July 26th, I posted the property and signed the affidavit. On August 7th, I conducted a final inspection, and I noted that one of the motorcycles is backed up and I'm unable to see the license plate. I have spoke to the property owner. He did show me valid registration for that motorcycle, so I'll be moving forward with that, with the motorcycle being valid under 40.00. There's still some debris in the backyard. The front's been primarily cleaned up, and the trash cans are, unfortunately, they're still in the rear yard where I can see them from the street. Other than that, he's, I would probably say about 90% there. What's before the board is the accumulation of trash, which as of right now, he would be in compliance of, 8-22. Duty to maintain private property and 8-52 are still open because of, I'm able to see the stuff in the backyard and things like that. And then 8-16, which covers the placement of your trash cans, 12 hours before, 12 hours after trash pickup, they have to be out of public view. That's the ordinance. 40.00 for inoperable vehicles, he is in compliance. All of the ordinances that I listed, I would like to establish, even the 2 that are in compliance. So he's got 3, 840, 852, and 816 that are currently not in compliance, and 8-22 and 40.00 are in compliance.
Thank you.
Thank you.
Would you repeat the numbers that are in compliance?
Are in compliance are 822 and 40.00.
It's not on listed.
Thank you.
Do you have any questions of what's been presented by the city, sir?
No, sir.
And do you have a response to what the city has stated?
No,
Do
no,
you have a defense?
just being overwhelmed.
Okay.
I can't hear you.
Just being overwhelmed with life in general.
I'll ask one question. How much time do you think you're going to need to take care of what's left of the issues?
Not too much long, because in the backyard, the weeds had grown into the debris, and I've gotten that out, so it should.
30 days?
Oh, easily.
Okay. I have no further questions.
Thank you. Do you want to summarize it all?
No, I don't think I need a summary. Thank you.
You want to summarize Anything at all in reference to your case?
No, basically, I understand what the city is wanting.
Great. We're going to close the public portion of this board and ask that we have a motion on the floor.
I'll make a motion. I move, based on the testimony, evidence, and facts presented in law, that at the time of the alleged violation, sections 8-16 and 8-52 of the Code of Ordinance of the City of Tarpon Springs was in force and effect. The respondent was in violation thereof.
Second.
Therefore,
Did you want to address the other code sections?
I do, but I'm gonna do these separate.
Well, the 8-40, there's testimony that it's in violation as well as 8-16 and 8-52. I just want to make sure that,
I understand.
okay, gotcha. Okay, so the roll call.
Roll call.
Ms. Telliar,
Yes.
Ms. Norfleet,
Yes.
Mr. Robinson,
Yes.
Mr. Kramer,
Yes.
Mrs. Dabbs,
Yes.
Ms. Wade,
Yes?
Mr. Weeks.
Yes.
Okay, so we need to,
Another motion.
Mm-hmm.
he needs to give his presentation relative to compliance date and fine amount. Compliance date as far as the two violations, 40.00 and 8-22 are in compliance.
I understand.
Okay.
I move
The
that the
other one's-
respondent shall have until,
Hang on, I think he's trying to include all four in the same motion.
No, I was a little confused because it sounded like the motion was that they were in compliance, but it was 840, 852, and 816 that were not in compliance. The motion only included two of those violations. I didn't hear 840 in the motion, the original motion.
because you said that was in compliance.
No, 840 is not. 840, 852, and 816 are not in compliance. 40.00
We don't
is-
have that on our list.
Okay, what? Oh, it was complied, so I'm sorry to confuse you.
Then
So
I need
the
to-
only one that is not in compliance, or I'm sorry, that is in compliance is 8-22.
Okay, I
Okay.
wish to amend my previous motion to also include 8-40.
Second.
Bobby?
Mrs. Telliar,
Yes.
Ms. Norfleet,
Yes.
Mr. Robinson,
Yes.
Mr. Kramer,
Yes.
Ms. Dabbs,
Yes.
Ms. Wade,
Yes?
Mr. Weeks.
Yes.
I move that the respondent shall have until September 10th to bring the property into compliance with code sections 8-16, 8-40, and 8-52, or suffer a fine of $50 per day for each day thereafter that the respondent remains in violation of said code sections.
Second.
Bobby?
Yes, sir, I'll be right with you. Mrs. Telliar,
Yes.
Ms. Norfleet,
Yes.
Mr. Robinson,
Yes.
Mr. Kramer,
Yes.
Mrs. Dabbs,
Yes.
Ms. Wade,
Yes.
Mr. Weeks.
Yes.
Motion carries.
Sir, you've been found in,
We have that other motion to,
oh,
Mr. Chairman.
sorry.
So there's one left,
To-
to define violation only, because it's in compliance, and so we need to address that before we close out the case, so.
Understand?
Alright.
Okay.
I move based on testimony, evidence, facts presented in law that at the time of the alleged violation, section 8-22 of the Code of Ordinances of the City of Tarpon Springs was in force and effect. At the time of the notice of violation, the respondents were in violation of said code section. However, they are now in compliance.
That's it.
Did you mean to include 40.00 as well? Am I
That's not
understand-
on our agenda.
I errantly mentioned it. Sorry to confuse the board.
Okay,
was a
so we
mistake on
don't
my
have
part.
to state that.
40.00 is not for consideration at all in this case.
Second.
Bobby, please?
Mrs. Telliar,
Yes.
Ms. Norfleet,
Yes.
Mr. Robinson,
Yes.
Mr. Kramer,
Yes.
Mrs. Dabbs,
Yes.
Ms. Wade,
Yes.
Mr. Weeks.
Yeah.
Yes, sir, I'm going to go ahead and summarize what the Code Enforcement Board has accomplished today. They found you in violation of Sections 8-16, 8-40, 8-52. You've been given until September 10th to bring the property into compliance. Should you fail to bring the property into compliance, by that time, a $50 a day fine will be instituted. You also have been found to have been in violation of Section 8-22. There was no fine associated with that since you're now in compliance. If any of these violations occur again within the next 5 years, it'll be considered a repeat violation, and the fine could be placed up to $500 per day for every day that the property remains in noncompliance. The Code Enforcement Board is going to issue an order. It will be issued within about the next 10 days, and you'll get that by mail. If you don't understand what happened here today, feel free to call the Code Enforcement Department, speak to Officer Gaston. He'll be happy to help you with answering your questions, but the property does need to be brought into compliance by September the 10th. Okay?
Understood.
Thank you.
Now we're moving on to number 11, repeat violator, Charles Savio.
I'm fine, how are you?
Officer Steve Gaston, City of Tarpon Springs Police Department, Code Enforcement. This is case number 19-800000452. The property address is 1420 Silver Oak Drive. Property owner listed as Charles Savio, Charles J. Savio. It's a repeat violator case for a period of 4 days. It was from July 10th of 2019 to July 14th of 2019. The cases that created this as a repeat violator was case number 18-800000879, which was a violation of 8-52. A fine of $25 per day for a total of $306 was assessed, and that has been paid. Also, a repeat violator for case 18-800000335. Those were violations of Code 8-40, 8-52, and 36.03. Fine assessed of $50 per day, a total of $1,302, and as of yet has not been paid. As I stated, the case before the board is 19-800000452. And Mr. Chairman, photographs and exhibits were given to the property owner.
Do you have any problem with the evidence being
I
presented?
do not. I've looked at the pictures and I agree with the overgrowth. I just didn't realize.
Sir, hold on.
Yes. Okay.
He would add one question for you. You have any objection to the evidence that's in front of you?
No, I don't.
Okay, we're going to be right back with you then. So we're going to accept the evidence in.
Accept the evidence into.
Thank you. Exhibit number 1 going before the board are all my photographs. Exhibit number 2, my notice of violation, notice of hearing, and any other associated notices. Exhibit number 3, administrative documents, case summary, property appraiser, and tax collector database records. Affidavit of posting and a copy of the sign is exhibit number 4. And exhibit number 5 is the affidavit of prosecution costs. All the photographs and exhibits that were given to the violator are exact copies of what's being presented to the board. All my notices are mailed to the property owner of record as determined by the Pinellas County Property Appraiser and tax collector databases. And all notice of violations and notice of hearing are sent, return receipt, as well as first class. And Mr. Chairman, you already asked for those to be placed. Thank you very much. We have had contact with the owner via our office via phone calls. The case started on July 10th of this year. The property was overgrown, not being maintained, and the trees were not providing the required clearance above the sidewalks, and the sidewalks were not free of debris and overgrowth. On July 11th, 2019, the repeat violator notice of hearing was mailed, and we did obtain a return receipt signed. Conducted a reinspection on July 18th, and it is in compliance. We were contacted by our office on July 14th that it was in compliance, hence the compliance date of July 14th. On July 26th, I posted the property and signed the affidavit, and the 2 violations before the board were violations of Code 8-40 and 8-52, which, as stated, are both in compliance. We're out of compliance for a period of 4 days, and the city has nothing further at this point.
Board have any questions for the city staff?
I misunderstood. At one point, I thought you cited 3 city codes, but there are only 2 that we're looking at.
No, what I was informing the board is the 2 repeat violator cases and what ordinances those cases had associated. And you probably heard 36.03, that's not before the board right now, but that was with that previous case.
Okay,
Yes.
thank you for clarifying.
Officer Gass, and then you're saying for 4 days, a fine had already been assessed at that point?
No, those were the previous
the
assessed
previous-
fines for
okay.
the previous cases.
Okay.
So the board is hearing basically a new case where he was a repeat violator because of those previous cases
Okay, got it.
for 4 days.
Okay.
Do you have any questions? for
I have
Officer
no
Gass? Any legal
questions.
questions? Okay. Do you have any questions of,
I do not.
thank you.
He needs to put
Public,
on- he needs to put on his case.
If I may, this property is a rental, and in the tenant's lease, they are to maintain the property, which they didn't, and I paid a fine for $306 already for this property. Excuse me. And they just have not kept up with their rent or maintaining the property. So as of Friday, a judge had decided in my favor to evict. So they will be evicted any day, as soon as possible. And the property has been taken care of since my letter that I signed for, more frequently than once a week to make sure that I'm on top of things. So I don't want any more code violations. And that's all I have to say. I just, from these pictures are accurate, of course. I just figured there's a 12-inch leeway, and I did not get on top of this as soon as I should have, because these pictures actually make it look worse than a more distant view, and it should have been taken care of sooner.
okay, thank you. Staff want to summarize anything?
I have nothing further.
Do you have anything else to say in summary?
No, that's about it.
I did have one question for, so the fine should apply for 4 days for 2 different things.
He was not in compliance for 4 days, July 10th to July 14th, correct? And the 2 violations are 8-40 and 8-52.
Can I ask you, oh, you've already cleaned it up,
Everything has
so
been
you're asking
In
him to come
compliance,
back.
got it.
You're in compliance.
When,
Okay.
whenever I get notice, things are taken care of quickly. I've gone to the code enforcement office, talked with Officer Gasson, and I remember Cindy Sander from before, and I said, could you just give me a call or knock on my door? Things will be taken care of instantaneously.
We're going to go ahead and close the public portion of this case, and I would entertain a motion.
I move based on the testimony, evidence, facts presented in law that the respondent, Charles Savio, was in violation of sections 8-40 and 8-52 of the the Tarpon Springs City Code from 7/10 to 7/14, and a fine of $50 per day had been established. In addition, I move that the city be awarded $69.50 for the costs incurred in prosecuting this case.
Can I hear a second?
Second.
Bobby, would you call the roll, please?
Mrs. Telliar,
Yes.
Ms. Norfleet,
Yes.
Mr. Robinson,
Yes.
Mr. Kramer,
Yes.
Mrs. Dabbs,
Yes.
Ms. Wade,
Yes?
Mr. Weeks.
Yeah,
Motion carries.
Shall I summarize? Okay.
please.
Okay, sir, you've been found in violation of those 2 code sections, 8-40 and 8-52, for the days of July 10th through July 14th. That's 4 days. The Code Enforcement Board has assessed a fine of $50 a day for those 4 days, a total of $200. The city has also been awarded its prosecution cost of $69.50. The total for the order will be $269.50. That order will be sent to you about the next 10 days. If you have any questions as to what you're supposed to do from here forward, you
No, I
contact the, I'm sorry?
I have no questions.
Okay. All right, thank you. So you'll receive the order then. And by the way, the city is not in the business of property management, and so don't be expecting a phone call from code enforcement when
I
your
understand.
property is overgrown.
It's a serious matter.
Okay, so, so you can pay that fine directly with the clerk's office after you receive the order. Please don't try to pay it before then.
Oh, okay.
Because they won't have the paperwork completed on that.
Okay.
Okay, all right. Thank you, sir.
Thank you.
Thank you.
You two take care.
Number 19-800007176, number 2 on our agenda, I'm sorry. 1404 Mirror Lane, Jean Eula.
Number 2 on your list.
Identify yourself and
Good
the
afternoon,
relationship
ladies and
to the
gentlemen of the
property.
board. My name is Samuel Kusha. I'm an attorney on behalf of the homeowner, or property owner rather, Mr. Gene Uloa.
Could you push that mic a little bit closer? Thank
sir.
you. Do you have any legal objections to the evidence that the city has being presented to the board?
No objections.
Thank you.
Thank you. Officer Steve Gasson, City of Tarpon Springs Police Department Code Enforcement. Case before the board 19-800000176. Property address is 1404 Meyer Lane. Property owner is listed as Jean Uloa, I believe. Exhibit number 1 going before the board are all my photographs. Exhibit number 2, notice of hearing, notice of violation. Exhibit number 3, administrative documents, case summary, property appraiser, and tax collector records. And the affidavit of posting and a copy of the sign are exhibit number 4. All the photographs and exhibits that were given to the violator's counsel are exact copies of what's being presented to this board. All my notices were mailed to the property owner of record as determined by the Pinellas County Property Appraiser and Tax Collector databases. All notice of violations and notice of hearing are sent both return receipt as well as first-class mail. And, Mr. Chairman, please accept all these exhibits into the record as evidence.
Bobby, will you accept those when they get down to you, please?
Yes, sir.
This is an interesting piece of property, so I'll kind of give you a little bit of a backstory with it. It's been before the board for some other reasons under 840. There was a legal argument, from my understanding, going back many, many years about where the actual property was built and some easement issues and things like that. At one point in time, the city had been a party to a legal case. We had been removed, the city had been removed from that legal case. And that's why this case is now coming before the board, because we're not a party to a civil matter or legal matter from this. I'm sure counsel can probably give you and he'll probably present some of the pins and needles as to why there's a legal case. I'm not going to try to stipulate. It was where the property was placed, basically, from my understanding. But substantially, this building has been in a state of partial construction for many, many years. It's the source of probably every 4 months or so, we get a complaint about the property and what's the city doing with it and where are we going with it. Unfortunately, because of the legal matter, it was kind of left, and we were just dealing with mowing the grass and taking care of it. It's finally come to a point where the city's decided to move forward with the fact that it's in a partial state of construction and something needs to be done. Kids have been playing in the building. I've actually ran some kids out a couple of times in the partial state of construction. The roofing material is now starting to come off the building, which, as you can appreciate, during this particular season, those are potential projectiles during hurricanes. So, as I stated, it's been in a partial state of construction for over 3 years and not completed. There was originally a permit pulled in 2013. That permit was closed out in 2014. As I stated, it was subject to litigation. There is no interior. The roof has lost areas of wood. There's no windows, doors, floors, other than the concrete foundation. And it is an attractive nuisance to children. On March 19th of this year, the notice of violation was mailed. I also emailed a couple of attorneys that I had that I had spoke to previously regarding the case. I never got any response back from any of those attorneys, and I unfortunately can't tell you who I emailed at the time, so I can't help you out with that. So the notice of hearing was mailed on July 8th. I kind of waited to see if we'd get any response back from anybody, and we didn't. And so that's why the notice of hearing was issued on July 8th. I posted the property on July 26th. And I conducted another inspection yesterday. It's still not in compliance. And up to this point, I haven't had any communication with either the owner or council up until about 15 minutes ago. And so basically what's before the board is 8-40. One of the subsections or one of the sections under 8-40 is that a house that's in either dilapidated condition or has not had construction going on or completed, it's basically sat in a state of not being completed for 3 years or more, falls under 8-40, which are the nuisance conditions. And that's the situation with this house. Obviously, the city'd like to see some sort of resolution, either completed, we move forward, or demolished, and it's no longer a hazard. At this point, that's all the city has.
You said a permit was issued
2013 closed out in
or what?
a building permit.
Okay.
A building permit was issued in 2013. It was closed out in 2014. I don't know the hows and whats and whys, other than by nature, building permits are only good for 6 months unless there is application to the building department to extend them. So it may have been extended one time, and that's why it was closed out in 2014. But I don't have the answer to that question in front of me.
I have a question.
Yes, ma'am.
We're considering this a violation since 3/19? That's when you sent the notice of violation?
Yes, that's when this particular case was started March 15th when I did the initial inspection. It's unique in the sense it's not just somebody didn't mow their grass. There's legal things and goes with it. That's why it's taken so much time. Honestly, there's a couple of exigent, and they're not incredibly exigent because it's been going on for about 6 years. But now some of the roof panels, as you can appreciate, time goes by, that stuff starts to degrade more and more with the weather and everything. And as you can see in one of the photographs, matter of fact, I think I took it yesterday or the day before, the southern side of it, which you can see on Keystone, is missing a couple of full sheets of plywood. I don't know if they existed at one point in time and they've blown off or what's happened with them. That's kind of why we're now wanting to at least get to some sort of resolution with this property. So, and that has gone on for years and we've understood that, but you know.
But we're considering this from the date of 3/15.
Certainly, yes. I mean, that's when the case started,
yeah.
yes.
Any other board members have questions? City? Hearing none. Do you have any questions of the city, sir?
No, I do not.
Do you have a case
Yes,
you
sir.
want to present?
So to give ladies and gentlemen of the board a little bit of background, to expound on what Officer Gasser had stated, this stems back from, I believe, 2013 or shortly there, before there. Initially, I believe there were 3 connected lots, essentially, were all purchased by one development group. That development group went ahead and hired a certified and licensed surveyor to come in and redefine the boundaries of the properties. That surveyor went ahead, conducted its surveys. Thereafter, once the 3 lots were now rezoned or, I guess, redefined, my client, Mr. Eloa, went ahead and purchased one of the lots, the one that is subject to this matter, I believe located at 1404 Meyer Lane. Mr. Eloa purchased that property from the development company under a contingency that he allowed the development company's contractor or who they associate with to develop the property. So based on the survey that the development company had solicited, they went ahead and took that survey and began construction on the home. Sometime through mid-construction, a dispute arose as to the location of the actual structure within the boundaries of that lot line. I believe there's a violation in terms of building code, in terms of set-off. I believe the structure itself is situated too far to one side of the lot, where it's encroaching on the neighbor's property, and at one point when the city was involved, encroaching on a right-of-way owned by the city. The issue at hand here is we have a pending circuit court case before the Pinellas County Sixth Circuit in which my client is acting as a plaintiff against, and we have it against 3 other parties, the development group, the contractor, and also the original surveyor. And the whole nature, or I guess core of this dispute is there's 2 determinations that need to be made. One, first, is the actual structure as it sits currently here today in the wrong location on the property? And if so, the second, determination that needs to be made is who's at fault. It's either one of three parties: the contractor, who may have misinterpreted the survey and began construction of the structure in the wrong location, also the developer for, hiring and using the surveyor, or the survey performed by its contractee to go ahead and move forward on the property, or more conceivably, the surveyor company itself who performed an improper survey. The issue at hand and the reason why the current structure is in a state of disrepair is because it would be financially futile for my client to complete construction of said structure if in fact it's determined that the structure is in the wrong location on the property and has to be knocked down anyway. Conversely, we are the position that the home cannot be demolished either to become into compliance, because there's a necessity for preservation of evidence for the pending circuit court case, in that if we destroy the structure, how are we going to determine where it was originally located, and further, whether it's in the wrong location or what party is theoretically at fault at the end of the day. So as that stands, we are, one more thing is we have most recently, we, on behalf of my law firm, on behalf of our client, went ahead and filed with the circuit court in case number 15004812-CI, again, in the circuit court, 6th Circuit, Pinellas County. We most recently filed a motion for preservation of evidence, in that we are asking the circuit court to issue a ruling to preserve the structure in its state as it is for the furtherance of making the determinations of the underlying litigious matter. Again, in kind of coinciding with filing this motion, we're also seeking, conferring with the other two parties, the defendants in this case, or excuse me, three parties. We are attempting to get them to set a trial date and get a case management conference on order so that we can push this to a resolution. Once those determinations are made within the court case, my client is in dire desire to go ahead and get in compliance with the board and the city at large.
Can I ask him a question?
Mm-hmm. Yeah.
We're not asking you to tear it down. We're just asking you to make it safe for the neighborhood, and photographs should suffice to show what's there right now. We just want you to put a few sheets of plywood on that roof and secure the entrances and exits, which doesn't preclude any of the things that you've asked for.
Yes, ma'am. Based on the notice of violation that I had received from Officer Gaston in the city of Tarpon Springs, and also based on the violation that was enumerated therein, the fact of it being in a partial state of construction led me to believe either one, they were seeking to level it and destroy it, or to complete said construction. However, securing the property, I believe, would be a tenable solution that I can offer to my client, and I'm sure that he would be agreeable to same.
Okay, I'm going to jump in. That was the comment by one code enforcement board.
That's not
Okay,
what we
that's
were
not the
going
direction of this
I'm
board.
Yes, sir.
asking if
Okay,
that
so I
would
don't want you
suffice.
going down that
Well, yes, sir.
path.
Yes, sir.
Okay, this board needs to make a determination whether there's a violation of this code section. And if there is a violation of the code section, set a compliance date and a fine. That's all your responsibility today is. So,
How much
We're
time,
going to go ahead and close the public.
let me
portion.
ask him a question.
Oh, I'm sorry. I apologize.
How much time is your best guess necessary to get all you just stated done?
Yes, sir. That's hard to say.
2 years.
Well, hopefully, no, not that long. Again, I don't want to give you any misinformation here. Given the fact litigious matters, given their very nature, with two parties alone take a very long time. However, with multiple parties, including this one, 3 defendants, I can't say, but we are actively pursuing getting a trial date. And so most likely courts now, I believe, are probably setting trials in spring of 2020. So that's probably the closest trial date. However, at the same time, while having that trial date on the books, it could force the other parties to potentially come to a resolution and or settlement so we can move forward.
Any other questions from the board?
I have a question. Regarding and I know the fact that it was built in 2013, the building code's changed a couple of times since then, which would require, I believe, significant changes to the walls themselves. Is it unreasonable, and I know, and I'm only asking this because we've done it in other cases where the foundation is left situated, but everything above has been removed. Is that a possibility? And it preserves the placement because there is enough photographic evidence, and I'm sure there was blueprints drawn of the structure itself. So would that be a possibility, leaving the foundation, because it would satisfy the city's issue? That's done frequently, because obviously a concrete slab is not a hazard to anybody.
Correct.
And I'm reading your motion right now, and I saw what was filed yesterday, correct?
Yes, sir.
So is that a possibility? And I'm asking on the city side to be able to take it down to a foundation, because I believe there's going to be a good chance that it's going to have to be brought to current hurricane standards, which may change structurally how it's done, the trusses and things like that. I'm just wondering.
Yes, sir. So, I mean, I can only proffer to the extent of my expertise and information. I myself am not a general contractor, nor do I know the exact position of how my client would respond to that, but I would certainly be willing to, again, counsel with him and see if they'd be agreeable.
Thank you.
I have one question. When was the lawsuit filed? How many years ago?
The lawsuit was filed, I believe, in 2013, 2014, and it's been set for mediation and trial previously. However, after the city kind of was dismissed from that case for the resolution of the right-of-way, it kind of stalled things out, but the parties are actively moving forward onto it. And again, we are trying to get this set for trial as soon as possible.
So the case has been pending 5 years. You're aware that administrative rule in the circuit court is that all circuit court cases are to be completed within a 1-year period of time?
Yes, sir. There's been multiple counsels on this case as well. So we are not, as Officer Gaston mentioned earlier, my firm, I guess, assumed representation after the initial complaint was filed. So as for why it's dragged out this long, I cannot say.
How long has your law firm been representing your client?
I believe since the later part of 2015.
So for 4 years, you've represented the client and haven't been able to get it to trial?
Yes, sir.
Okay.
We've explored other options through mediation. Otherwise, again, consideration would potentially be granting a variance for both lots. I know that would be more before the land use section and not necessarily code enforcement. So I'm going to table that kind of idea for now. However, we are actively trying to comply with code enforcement and move forward on this case.
I don't have any other questions.
More questions? Okay, I'll entertain, the public portion of this is closed, and I'll entertain motion at this time.
I move based on the testimony, evidence, and facts presented in law that at the time of the alleged violation, Section 8-40 of the Code of Ordinances of the City of Tarpon Springs was in force and effect. The respondents were in violation thereof.
Second.
We have a first and a second. Roll call, Bobby?
Ms. Telliar,
Yes.
Ms. Norfleet,
Yes.
Mr. Robinson,
Yes.
Mr. Kramer,
Yes.
Mrs. Dabbs,
Yes.
Mrs. Wade,
Yes.
Mr. Weeks.
Yes.
Motion carries.
Time
We
suggestion?
ask you about time and.
As I stated before, the attractive nuisance to the kids is kind of an issue, but it has been going on for a long period of time, so it's kind of unrealistic on the city's part to say we have to do something rapidly. Council stated he believes he can get a trial early spring 2020. September, October, November, December, January, February, March. I would say that if we can get to a resolution within 9 months, or alternatively, if we can find an answer to taking it down to the foundation, then they'll be in compliance with continually maintaining the grass and things like that. And that'll put the case into compliance quite rapidly. I don't know if it's possible to ask the board to have two parts to that, because they can be in compliance in a very short period of time if they're able to demolish the structure and leave the foundation, and that satisfies their legal request. Or otherwise, at least begin the rebuilding process at about the time of their case. As Mr. Trask stated and council stated, this has been going on since 2015. There's an enormous amount of information in public records for this case about motions filed and things like that. So I think in the city's best interest, we need to try to get a definitive date. And I do think that the 90 days, the putting it basically 9 months from now would be to be in compliance. And that would be either we're now rebuilding the building, or at least we've taken it down to the foundation to satisfy both aspects, because I do, you know, the city does appreciate his case, needing to preserve the evidence, but the foundation is also going to preserve his property rights and his placement. So,
First, have had to deal
and
with
obviously,
that.
it's not going to be an attractive nuisance because kids really have no desire to play on a piece of concrete. So, that's my opinion.
So what's the problem with just securing?
To secure that building, I think we'd actually have to have building permits because you have to put doors on it. The city code doesn't allow boarding up of a building per se. So in order to make it enough secured, you'd have to have a building permit. Well, we kind of have issues with the whole legal case of getting a building permit to secure it. It's a weird catch-22. I think council probably agree. We're in a weird situation with that. Because he's not gonna be able to get a permit because of the legal case.
Just seems like a long time for, it's already gone on for a long time.
Yeah.
And I
It
feel for all
has,
those
and the city's now brought it because of the changes to the case. And we would like some resolution. The fact that it has been going on for so many years, 9 more months is not, in the city's opinion, unreasonable. If they can take steps to try to do their best to secure it, even if that consists of opening it up a little bit where it's, you know, it's easier to see inside of it, or take it down to the foundation and then they're simply in compliance, they can take as long as they want on their civil case, and the city doesn't have a problem with that. So those are kind of our position, if you will, to solve it as quickly as possible. So, but I do get civil court cases kind of do take a little bit of time.
But
Mr.
fencing
Trask
it
can
is
probably
not
tell us
an
more.
option.
No.
I'm sorry?
No, fencing it is not an option.
because they don't know what the borders are.
Well, he has a.
You know, I believe they probably could get a survey and they probably could put a fence up around it. That could be an option, but that does not change 8-40. That it's been in a state of no construction for 3 years. So it just makes it safer, yes, but it doesn't change the violation.
Doesn't
Arch, is
stop
yours-
the roof from blowing off.
It doesn't stop the
when
roof from
next
blowing
turn
off and things like that, correct?
Landing in my yard.
Correct. That's a pretty long flight,
Or some child getting severely hurt on it.
yes.
But we feel,
This is question and answer period. You should save your discussion about the actual motion after it's been made. So far, we've got a question of how much time do you think it is the appropriate time for compliance? You've answered that question.
Yes,
Are there any other questions of Officer Gasson? Okay. So now it's time to close the public hearing then,
Close the
and
public hearing, and I'll entertain a motion.
I move that the respondent shall have until March of 2020,
March what?
March 1st of 2020, to bring the property into compliance with code section 8-40, or suffer a fine of $200 per day for each day thereafter that the respondents remain in violation of said code sections.
Second.
Roll call, Bobby? Please.
Mrs. Teliar?
Yes.
Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Mrs. Dabbs?
Yes.
Mrs. Wade?
Yes.
Mr. Weeks?
Yes.
Motion
I'll
carries.
summarize. So, sir, your client's been found in violation of Section 8-40, has been given until March 1st, 2020, to come into compliance. Should the property not be brought into compliance by that date, a $200 a day fine will be instituted. Hopefully, that will give some leverage to you in your case to get it completed. The order will be entered within the next 10 days and sent to your client at his address, 1404 Meyer Lane, as that is what is listed by the property appraiser's records. If you want a copy of that to be going to you, you can provide your card to city staff here, and they'll be happy to send a copy of it to you as well. If you have any questions as to what happened, you can call me after the meeting, since you are an attorney, or city staff. If you want to do that too, I'd be happy to respond.
Yes, sir. Thank you.
Here's my business card if you need it. Okay.
Hey.
Thank you.
Now,
Sir.
Pat Politis, number 12, 19-484. The end. This is a repeat violator, 385 Whitcomb Boulevard, Perry Papalides.
Yes, sir. And I have Sharon Varghese here with me, the tenant.
Okay, great. Do you have any legal objection to the city's evidence being placed?
I do, sir. All this evidence was obtained illegally by trespassing on the property, failing to get the tenant's permission to enter the property, entering the curtilage of the property behind a brick wall. There was no authority for him to enter a backyard that was fully fenced with a 6-foot fence all the way around it without permission from the tenant. Ms. Varghese, did Officer Gasson get your permission to enter the yard?
Hold on a second, we're not gonna start
Wait,
testimony. This
wait.
is legal argument, okay?
We're asking if you have any legal objection to the city's evidence. And if you do, I need to know which, and you say all the evidence is illegal.
Yes, sir. All the evidence was gathered illegally.
Okay, so the city should be able to respond to that.
Can you respond to that, please?
Yes. The granddaughter of Ms. Varghese, I knocked on the door. She answered the door of the house. I said, "Do you live here?" She says, "Yes, I do." I said, as it was suggested by your landlord, Mr. Patsalides, I should come knock on the door, and do you mind if I take a look at the yard to try, because we were here last month for a lawn mowing issue, to see if the violations were in compliance? She said, yes, she could. Yes, I could. And I went around back, took photographs of additional evidence that I wasn't privy to from the roadway. So all of these photographs were obtained, and the tenant there did advise that the granddaughter lives there. So she is a tenant. She may or may not be on the lease. I don't know, but she's a resident, and she gave me consent to go into the backyard and take photographs. So the city's position is they were legally obtained, and they
Okay,
should be allowed
your
into evidence.
objection is overruled.
Wait a minute, sir. I've got evidence yet. You haven't allowed me to present.
Sir, Mr. Patsalides, you don't get to present evidence on that issue.
No, regarding the trespassing.
Okay,
He's claiming that this lady gave him permission, and I've got an affidavit from her saying she was visiting her grandmother, and she did not give him permission. In fact, she asked him to wait while she went to get her grandmother, and he also alleged to her that he knocked on the front door where her grandmother was and nobody answered, and then had to go to the side patio door crossing the property and go into the back of the house to knock on this other door to get permission from a lady who is visiting her grandmother. Now, that doesn't sound proper to me, and I've got affidavits from her, and I've got affidavit from Miss Sharon Varghese that claims that she never gave permission, and the lady that he claims gave him permission says she didn't, under oath, notarized.
Okay, can you provide that to, Mr. Chairman? We need to ferret this out a little bit more. Can you provide those affidavits to the city? And then what's going to happen is they're going to need to look at those and respond here quickly.
I'll be happy to read them too, sir.
Not until they come into evidence.
Give me just a second, because I put notes in here as far as what her name was and stuff. So bear with me while I pull them up.
can do that. Take a 5-minute break.
Go ahead and take a 5-minute break while the officer
Oh,
looks over.
I'm done. If you're taking a break for another reason, that's fine, but I'm good to go. I just needed to find my notes where I wanted to compare names. The only thing I can tell you is I put in my notes immediately afterwards, and I said I was allowed on the property to conduct my reinspection for another case by Olivia, the resident granddaughter of the tenant. I spoke to Ms. Varghese at length, probably a good half an hour outside of the front of the door. After I did the inspection with the granddaughter, she did go back inside. She came back out and said, yeah, that's fine, I have no problem with that. I can't cross-examine her and ask her why suddenly her information's different. But as far as that goes, I have a long-standing history because every single time we have code board, Mr. Patsalides alleges a trespassing violation. I don't do that. I can get the information just fine. As a matter of fact, I would like to submit into evidence Mr. Patsalides' photographs because if there is some doubt about mine, he basically took the same pictures of his own backyard. So I'd like to submit those to evidence. If he wants to evaluate his own pictures, I'll submit them as well as city's evidence.
Okay, so we need to address the ruling on whether or not you're going to, can you pass those affidavits down? And we need to see them directly up here.
Yeah, I asked her specifically, one, does she live here? Because, even a non-listed tenant on a lease is allowed to give permission to enter the property. With the long-standing history, if she would have said no, if she would have said I've talked to somebody else, I would have gone around to the other door and talked to her. I ended up talking to her at length, and she never revoked my privilege to come onto the property. We had a long conversation about how her landlord is and so on and so forth. There was never a mention of, I'd like you to leave, I'd like you to get off the property or any of those kind of things. So as far as what convinced her to write a false affidavit, I don't know. But I will flatly say that because she did 100% give me permission to go on the property. And she did state she lived there. So I don't know what else to say. I mean, that's the information I was provided at the time.
I do know one thing to say.
Hold on a
that
second.
Before,
Hold on.
Yes, sir.
Let us read these. Okay, that's just for you. That's not for the board yet.
Oh, right here. Sorry.
Okay, Mr. Patsalides, you had something else that you wanted to argue relative to the motion? Any additional thing other than these two affidavits?
yes, sir, I've got pictures of the property showing how he had
That's
to
not going to help on your argument.
cross the property to get to that back door without permission.
Yeah, that's
Plus, it's on the record here that I've ordered him numerous times that I did not want him trespassing on my property, and he was aware of that. In the past, the last code board, he found 2 violations.
Okay, we're
Didn't
gonna-
knock. Just
let's-
wait a
let's-
minute.
no,
Just didn't
no,
knock on the
let's stick
door
to-
at all.
That's a
to let-
different case, Mr. Patsalides.
Yes, sir, but it's a pattern. He did not knock on the door to notify the tenant of the violation. He didn't send the tenant a letter, but this time, all he had to do was go back and observe from the outside that the grass was cut. There was no reason for him to knock on a door to ask permission to go in a backyard other than to try to find another violation, and he did it illegally. There was no reason for him to knock on the door.
Okay.
The violation was observed from the street, and it was all cleared. He didn't have to knock on anybody's door. And if he did, he should have done it the first time to help the tenant come into compliance, but he failed to.
Okay, Mr. Chairman, you need to make a decision based upon the testimony that you've heard from the city's witness and these 2 affidavits. Of course, Mr. Patsalides wasn't present, so he's making arguments, but his testimony should not be given as much weight as these two affidavits and the testimony of Mr. Gasson, but you are to make a decision as to whether or not you want to overrule the objection as to the photographs coming in, or you want to sustain it. So if you overrule it, the photographs come in. If you sustain it, the photographs and other evidence do not come in.
The objection's overruled.
So then,
So the city bring
Should
your
proceed.
evidence into the,
All right, and I would like to add additional exhibits. I'd like Mr. Patsalides to confirm that these were his photographs taken of his property by him, and then I'd like to place those into evidence as well for the city.
you can call him as a witness when you're done testifying.
Okay.
Yeah, why don't you finish your testimony? You'll have an opportunity to cross-examine, then you can call him as a witness.
All right, thank you.
Yeah.
Officer Steve Gasson, City of Tarpon Springs Police Department Code Enforcement. This is a repeat violator case from July 15th, 2019 to present, and we have not been notified that he's in compliance. There's numerous repeat violator cases. One that this board heard the previous month, 19-800000396, violation of City Code 8-40 and 8-52, a fine of $75 per day for a total of $2,584 has yet to be paid. Repeat violator for case number 18-800000692, which is a violation of City Code 8-46-1, 36.03, 13302, and 3207, $25 per day, a total of $366, also not paid. Repeat violator for case 16-800000387, violation of 8-40, 9-1, and 303.1. That one was established. There was no fines assessed at that time. This is case 19-8000484. The property address is 385 Whitcomb Boulevard. Harry and Anna Patsalides are the listed owners. Exhibit number 1, going before the board, is my photographs. Exhibit 2 are notice violations and notice of hearing. Exhibit number 3, administrative documents, case summary, property appraiser, and tax collector records. Exhibit number 4 is the affidavit of posting and a copy of the sign. Exhibit number 5 is the affidavit of prosecution costs. All the photographs and exhibits were given to the violator, exact copies of what's being presented to the board. All my notices were mailed to the property owner of record as determined by the Pinellas County Property Appraiser and Tax Collector databases. And all notice of violations and notice of hearings are sent, return receipt requested, as well as first-class mail. And Mr. Chairman, please accept these into the record as evidence.
Bobby, when they get down to you,
Yes, sir.
please place them into evidence. please.
Yes, sir.
So we have had some sporadic contact with the owner via email. Initially, the inspection was conducted on July 15th. As I stated earlier, I was conducting the reinspection on last month's case, which was for overgrown grass. As Mr. Patsalides has stated, he doesn't want me to trespass, so at this point in time, I decided to take Mr. Patsalides' advice, knock on the door and see if the tenant would allow me to reinspect with the intention of being able to close that case out. In the process of the reinspection, I discovered a large amount of debris, a dead tree, some other material in the backyard that would be considered debris. There's discarded wood, plastic bins, discarded metal drain pipes, plastic bags, vegetative debris, PVC pipes, discarded screens, etc., as noted in the photographs. So on July 16th of 2019, the repeat violator notice of violation was mailed. It was return signed. I posted the property on July 26th and signed the affidavit. What's before the board is violations of 8-40 and 8-52, which are still active. The office has not been notified that those violations are in compliance. So as stated, it's from July 15th to present. For the board's information, I mean, Mr. Patsalides has been here quite a few times. He's raised some issues about trespassing and things of that nature. I always take steps to make sure that I'm not. And in this particular case, I spoke to the granddaughter who was there. I ended up actually speaking to Ms. Voorhees for, like I said, a long period of time with the specific intent of trying to clear the case out. Unfortunately, in doing so, the photographs that Mr. Patsalides presented to the board didn't exactly show everything. So I asked. They had the opportunity to say no, and I would have left. I couldn't see anything from there's two doors on the house. There's one kind of what would be the southwestern side, and then there's kind of a main door. I went to the first door that was closer to the driveway, and that granddaughter answered. The grandson was there. He's very pleasant. He actually likes the police. And I conducted the inspection in the backyard. She then said, oh, my grandma's around front. So I went around and talked to Ms. Varghese for probably about half an hour or so. We had a rather long discussion about issues with the property and the landlord and things like that. So as far as the city goes, I'm not going to expose the city to potential legalities by trespassing on somebody's property. In this particular case, and we'll see here in a few minutes, his own photographs show the violation. So regardless of mine, where I was standing, how I got them, which was legal, his own photographs show the violations as well, which the board will have an opportunity to see here in a little bit. This is hopefully not going to be some long drawn-out thing, which I have the fear that it may become. But it's a simple matter of Mr. Patsalides just doesn't seem to want to take care of his properties, and that's why we're here. So as of this point, the city has nothing to say, but I'd like to reserve my right, obviously, for questions and closing.
Board have any questions?
Yes. Can you tell me an approximate age of this granddaughter? I mean, is she 6 or
Oh,
is
no,
she
she's
26?
probably in her
or-
30s. She's in her 30s, had maybe about a 6-year-old son.
Okay. Helps completely.
Yes, and as a matter of fact, Ms. Varghese explained to me the situation with her husband, handicaps, all the kind of things that the family's been going through lately. We had a pretty significant discussion for a rather long period of time, and there was never any discussion about, matter of fact, I said, your landlord has a tendency to not to want me to trespass on your property. She goes, I'm aware he says that. So, I mean, we talked quite a bit. It wasn't get off my property and leave or anything to that effect. It was quite the opposite, as a matter of fact. And I'm a little bit astonished by both of the affidavits that were presented at how glaring they are at being false from the conversations I had. Again, I've been doing this for 22 years. I'm not going to risk my career over overgrown grass or piles of debris in a backyard. It's not worth it. And contrary to whatever Mr. Patsalides may think about me, it's another case, and that's all it boils down to. So, but yeah, she was an adult. She made it very clear that she lived there because I specifically asked that question. So I could obtain that permission from her and be able to legally justify being there. Mm-hmm.
Any other questions from the board? Mr. Papley? Sorry.
So there's an outstanding fine that hasn't been paid from a previous violation,
Yes, ma'am.
but that is not something we're considering now.
No, ma'am.
Okay.
That's just informing the board of previous fines and their status, that's all.
I have a question.
You
Am
have,
I reading
yes.
this right?
Go ahead.
So based on this case, this is the 4th time 840 is in violation. This case has not been adjudicated yet, but there were previously 3. Is that what I'm saying?
But they may be associated with different properties that Mr. Patsalides owns.
Same owner.
Same owner, same city, those kind of things. Yes, sir.
Mr. Papley, do you want to present your case now?
No, I want to ask him some questions, please.
Oh, you can do that.
When you say you were talking to Mrs. Voorhees and you extensively had conversations with her, was that after you had already trespassed on the property and taken the pictures and then talked to her?
No.
Or was it before?
I didn't trespass on your property. I was given permission.
Was it before you took the pictures or after you?
It was after I took the pictures.
Right. So you had a nice little talk with her afterwards, extensive, trying to make the board think that you got permission to go on there.
I never
It
said that,
was
sir.
after the fact.
I never
Is that
said
correct?
No, I never said Ms. Voorhees gave me.
After you took the
Yes,
pictures.
I've established that. It was afterwards.
Mrs. Voorhees, how old is your
Hold on
daughter?
a second, this is
whoa,
cross-examination.
I got a whole bunch of questions. First of all, I object to these pictures that you gave me because your pictures and my pictures are mixed in together. These are not all my pictures. And clearly, this picture here with Mrs. Voorhees sitting there and no branch in the back cannot be the same picture as you submitted with a branch in the back.
Do we have an email?
They can't be the same because it's the same scene and there's no branch.
Well, I have them in the email of what you sent, so.
Hold on a second. We're not going to do
Okay.
this.
That's fine.
This is cross-examination, Mr. Patsalides. This is not your time to put on your evidence.
Okay,
Finish
I
your
got
questions, and
Yes,
then we'll
sir.
come back to you. We just need to keep some, a little bit of
How did you
formality.
receive the initial complaint, Officer Gasson?
Are you talking last month's or the one I was?
Sir, the first complaint about this, whenever it was, for this situation where you did 2 violations at the same time for the same violation, grass. You got 52 and 40 for tall grass.
Are you speaking of case number 396 that
Yes,
you
sir.
were heard here last month?
Yes, sir.
It was a citizen complaint.
Anonymous, right?
I believe so, yes.
Yeah, they all are.
Well, no, I actually have quite a few that aren't.
Okay, in regard to that complaint, did you go to the address of 385 Whitcomb Boulevard to verify that the grass had been cut?
Yes.
Had it been cut?
Yeah, mostly yes. There was a couple places I had an issue with underneath the trailer in the back, so.
And you could see that from the street?
I could, and that's the reason why I went to the door to investigate that further and to see if I would be given permission to investigate that further.
Okay,
Because I can't see the whole backyard from the street.
The original pictures that you submitted as evidence, which I have here, do not show the backyard. They just show the
I object
street.
to that because that's a previous case.
You're presenting your case, and I'm asking you to give him a question.
Okay, did you issue a letter of compliance on those first 2 cases?
I believe yes, we have an affidavit of compliance
So
For
why did you just tell the board that you still have an open case?
because
From the
we're
old
here on an open case.
This one, but not the last 2, right?
No. I didn't ever say there was open cases. I said they were your previous cases where fines were assessed that had not been paid. That's what I noted.
Well, actually, I had till, according to the board, we were here on July the 11th, and the board gave me till July 15th to remove that branch in the backyard, which I did. And I called you, and you went back to comply.
And then new violations were discovered upon the inspection. So a new case was opened.
Right.
Right.
But you cleared this, right, from those first 2?
Case number 19.
So there's no fine on the 52, correct?
We're not talking about any other fines. We're talking about one case and one case only, and this is the one that we're discussing at the present time.
Okay. So other than the
Further
current
questions?
case, there was no prior violations there, right?
I'm sorry, rephrase your question?
Other than the current case that we're discussing now, there were no prior violations there. No existing violations. You had cleared them.
When I went on July 15th, the original 852 for overgrown grass, because that's all I was privy to at the time, was in violation. It did not seem fair that once the new violations were discovered, to continue those on because they were not discussed in the notice of violation. Although 852 has that definition, we felt it would be more appropriate because the board said, come into compliance by mowing the grass, that kind of stuff. Those were the violations discussed. That violation was complied on the date that you stated it was done.
Okay.
And then, upon discovery of the new violations that I was not privy to before, a new case was opened. Unfortunately for you, you're a repeat violator, and the fine started that day. So that's the situation we're in.
So when you came this last time, this current case, from where did you observe, you came to look at compliance with the other cases? From where did you observe compliance? Because the other cases pertain to a patch of grass between the sidewalk and the street, and in the tip of the yard where you photographed overgrown grass that had not been cut by Miss Voorhees and her son previously. Anyway, I'll question her later. But why would you have to go in the backyard to correct the tall grass on between the curb, between the sidewalk and the street, at the outermost part of the yard, next to the roads where the intersection is? That's where the violation was. Why would you have to go inside?
That's not true. As you stated, it was also in the backyard, correct?
No.
It wasn't, you had no violations previous in the backyard. Okay, well, here's the reason why. Because of you, Mr. Patsalides, I decided to actually get my tape measure out and ask, because in the first exhibit of exhibit number 1 that's been entered, there's a trailer in your backyard, photograph taken from the street.
Yes.
It has pretty long grass underneath of it. But because Mr. Patsalides questions everything I do, I decided to see if I could actually measure it, in all fairness to you, sir. So for that reason,
This picture here?
yes, sir, does that not appear to have long grass at the back of that trailer? Are you able to tell it's more than 12 inches from that photograph?
It's less than 12
Oh, it is.
inches because
So the
I've
bush
got
on
an
the right of the
exhibit
trailer-
here
okay,
that
so
I'll
the bush on
present
the right of-
later that shows it.
Okay, Mr. Patsalides, I don't know what else to say, okay? I decided to take a bit of your advice and do 2 things. Knock on your tenant's door and take a tape measure, because those are the 2 things that you seem to bring to this board consistently that you allege that I don't do.
Where's the tape measure here?
I didn't take a picture of it, sir.
Where is
But
it?
your witness, if she was here, could testify that I used it. Okay? Maybe she should have put that in her affidavit, but she didn't. Okay? So here's the deal. I measured it because you frequently suggest I don't know how tall grass is. So I decided, in all fairness to you, measure it. And you know what the cool part was? It was under 12 inches. So I put you in compliance for it. So I did exactly what you asked me to do.
Good.
Unfortunately, while I was in your backyard, I noticed all the other violations. So again, I had to open another case, in all fairness, and that's the position we're in. Hopefully that answers all those questions.
No, it doesn't,
I
because
didn't think
you
so.
still didn't have to go in the backyard. And Ms. Voorhees just said you didn't use a tape measure.
She wasn't in.
Questions?
Didn't tell her that you used a tape measure. Okay, did you say you went to the front door of the house and knocked on the front door?
He said that
I did.
already.
Okay, and how many times did you knock on the front door?
To the point somebody answered. So it worked.
No, the front door, sir.
Sir, I knocked on a door that is on the front side of the house. I don't know the layout of your house. There's 2 doors. And I knocked on a door that's facing the street.
Okay, was there a walkway leading to that door?
I don't recall, sir.
There was a walkway leading to the other door, right? The front door?
I believe so, yes.
So
Or
you
the other door,
You didn't
yes.
go to that door.
Not initially, because weirdly enough, I went to the closer door.
All right.
And magically, somebody answered it. Who lived there?
So you did not go to the front door, that's all I'm asking.
I didn't go to the door you're alleging is the front
And
door.
what was
yes.
the purpose of you going to the front door, or to the door that you went to?
I've covered that already. I answered that question already. To make it simple was to honor your request of gaining permission so that I could.
Wasn't any violations at the time, you just
All right.
cleared them, you said.
I don't know what else to say, Mr. Patsalides.
There was no
We
reason
discussed
for
this.
you to go.
That's your opinion, yes.
Yeah, because you were,
Questions, Mr. Patsalides?
so it is true that you failed to send a letter to the address where the violations occurred previously. Did you send one this time?
I don't know. Beth usually sends those out. You'd have to bring her up, swear her in, and ask her that question.
So you knocked on the door, but you didn't send a letter according to her.
I'm not legally required to, sir.
I know.
We're legally required to send
No, you're
to the
telling
property
me you want to
owner.
accommodate me,
And we've
but you're
done that a
not
number
doing
of
what
times.
I asked you to do, to send my tenants letters
Well-
so that they can help
Questions,
me
Mr.
keep things in
Patsalides?
compliance.
Please, we're trying to get it completed.
Okay, Can you explain how the person living in the house would know there was an issue to correct if you did not personally inform them or send them a letter explaining what had to be done?
Maybe their landlord would tell them, as a good landlord would, because you got the notice and you might call them up and go, hey, you got a violation, you should probably take care of this. I don't know. I'm required to let you know.
Yeah, but if you were, are you interested in gaining compliance, or are you interested just in fines?
I'm interested in following the legal process I'm bound to do under Florida state statute.
Well, I think if you were interested, I'm asking, interested in compliance, I would think that you would make an effort to let the tenants know that they were out of compliance and what they needed to do to come into compliance, since they're living there and
Questions,
maintaining the
Mr.
house.
Kaplan?
Isn't that true, sir?
I cover the legal basis. If have the opportunity, I may or may not, okay?
Let me ask you this. If there was a walkway leading to the front door, why would you go to a side patio door behind a brick wall?
There's no brick wall. There's a door that's right off of Ashland. I parked there near the gate where I took the photographs and saw that and said, and I walked to that door.
So there's no brick wall there?
I don't recall the layout of yours. I know there was a door there. I knocked on it, and as I stated before, and I'll
But
state
why
again,
wouldn't you go to the front door instead of going
I
to a
told you
side
that.
patio door?
I went to the closest door. I can't tell what living arrangement you have.
But
Here's the interesting part.
Did you have to cross the grass
They have
to
been
go to that
these
door?
questions have been asked and answered
Did you cross the
over
grass?
and over again.
I suppose.
I'd like you to present your case now, please.
I have some more
I-
questions, sir.
As long as it's nothing that's been asked and answered.
Okay, the affidavits will speak for themselves, and I don't have to ask him those questions, what he told her and what she told him.
That's correct. You don't have to repeat everything he
All right.
says or everything that someone else has said. I've marked them and I provided them to the clerk as being proffered into evidence. Okay.
Thank you.
Yeah, I don't know if I still have them.
Now, you knew who the tenant was at that residence, didn't you?
Well, she's been to code board, so I've never actually seen her at the house. So until I knocked on the door and then her granddaughter had me talk to her later, then I actually knew she lived there. I mean, you'd presented her as a tenant, so yes.
So why didn't you ask for her?
I have no idea.
Legally, we have to let you know, and we've said that over and over again, we do not let tenants know of an issue because you own the place and you're responsible for doing something about the issues
I understand
that
that,
this
sir.
man brings up.
I'm trying to get to the trespass. He went up
There
there
is-
without the tenant's permission and
He's
never
asked, you've
seek-
asked that and he's answered
seek
it
the
over and
tenant's
over
permission.
again.
So isn't the entire backyard surrounded by a 6-foot fence?
Except for the large gate, yes.
And the falling wood fence,
Sir?
and the falling wood fence in the back.
There is no falling wood fence.
Okay, don't argue with him.
I'm not gonna argue.
Yeah.
Okay. Just the gate, not the fence. And he said in the back. Sir, do you know what curtilage is?
The legal definition of curtilage?
Yes, sir.
Yes.
What is it?
Legal curtilage is the area surrounding the outside of a house or residence, including front porches and things of that nature.
Is it Fourth Amendment protected?
Depends on the circumstances. If I have a legal right to be there, then not. And to knock on a door, which is, I can pretty much guess the direction you're going, so I'll solve the question now. To
Okay,
knock on a door
that's all right. Go
is not
ahead.
a violation of the Fourth
Go
Amendment.
ahead, sir. That's all
Okay.
right. Did you post a sign on the front lawn of this property?
Yes, sir, I did. Oh, wait, the front yard or the side yard? Where the side door is that I knocked
Did
on?
you place a sign anywhere on the property?
Yes, I did.
How did you get to the sign? Where'd you place it on the property?
In the grass.
Huh?
In the grass.
Yeah. How far in on the property?
I don't know, but I'm guessing you measured it. So maybe you could tell me. I can't tell you. I
Why would
basically
you
stick
have
it
to
in the
go
ground
on
and I
the
push my feet
property
in
to
it.
put a sign in when you could put it right next to the street or the curb?
Basically the same place I put it everywhere.
But you didn't get permission to do that, did you?
Nope, sure didn't.
Okay. That was part of the curtilage of the house, wasn't it?
No,
Where you placed the sign?
it's not part of the curtilage. It's your front yard. It's not a porch. It's not whatever. I placed a sign in your yard. I stuck it in your yard. It's been placed in your yard. Matter of fact, it's been done numerous times to your yard, so.
Thank you for bearing with me. I'm trying to skip over to questions that have already been previously answered. Sir, how are you dressed when you are performing your code enforcement activities?
Just like I am now.
You carry a weapon
Yes,
that
sir,
can
I
be
do.
seen by the public when you're
Yes, sir, I do.
conducting your code enforcement activities?
And I have a badge too. And a marked police car.
Okay. Do you think that carrying a weapon might tend to intimidate the tenants or people in general when conducting code enforcement activities?
Probably have to ask your tenant.
Did you make any accommodations for my tenants at this location, knowing that they're handicapped and that they cannot take care of themselves?
the same tenants you make mow the yard, I was supposed to make accommodations for? What kind of accommodations? Like a hotel, apartment? What did you need me to do? Talk to them a different way?
I'm asking a question.
And I'm
Did
trying to
you make
answer
any
it, but
accommodations?
you're asking me
for the
accommodations. I don't know
people
what kind I'm supposed to
that
give
are in
them.
the house as far as overlooking things, small things, because of their condition?
Okay. I'm having a difficult time with this because you are telling me that your tenants, the handicap tenants apparently, are required to maintain the yard. Now suddenly I'm supposed to give them some sort of accommodation because
I didn't say you were supposed to. I asked you if you did.
Okay,
If
and
you
I asked you
considered
what kind
and
was I
making any
supposed to give them?
accommodations.
What kind was I supposed to give them?
I don't know.
Are we addressing some sort of an ADA issue or what?
No.
Okay. So I did not provide them with housing or anything
I
like that?
don't have any
I did
further
not.
questions.
Thank you. Will you present your case now, please?
Yes, sir. Okay. I've got two more affidavits to submit as to when the grass was cut.
Objection, irrelevant.
Regarding the dates set for any fines.
You want to hand them over?
That's not this case. That's another case.
Yeah.
You're on here twice. You're on my agenda twice.
So I'm gonna come back again,
Yes, sir.
so I should save those for the next one.
Yeah, this is a different
This
case, so
has
I object to
nothing-
them.
Those have nothing
I
to do
think
with
Tom's
this
probably
case.
still gonna need them.
Okay.
Yeah, let me just hang on to those. We'll make sure that they're here for that case.
What's that? Okay, I've got some pictures here of the house, the side door, the front door. And I'd like to submit these.
No objection.
No, yeah.
Got a bunch of them.
Stay right there, Beth, if you would. He's going to hand you a bunch of photographs. We don't need to see them on his.
Well, do you want to look at those first? Because I got a bunch, there's about.
I just give them to them all at once, and then you can testify. If you want to number them, it may be helpful to you in
I
your
haven't
presentation.
yet.
Okay, do you want to number them?
I've got three with the signs showing how far the sign was placed on the grass. I've got those showing where the side door was.
Got it. We already heard all that. Do you want to number them, or do you want to just submit them?
You
don't have to. I'm just asking you if you wanted to.
Yeah, I'll
Do
submit
you-
'em.
Okay. Okay, hang on, Beth. He's going to have hand you a whole bunch more. That way you don't feel like a robot running back and forth.
Okay, should I talk about them or not? Just submit them?
I think you should. Yeah.
Yeah, okay. Well, this picture here is a picture of the front door. So's this with a walkway. So's this. This is a picture of the driveway. This picture of the brick wall where the patio door is behind.
I do want to see
This
that.
is another picture of the garage with the brick wall with the patio door way behind the brick wall. This is a picture of the door at the patio. There's all grass in front. So you'd have to trespass on the property to get to that door. Here's a picture where I used a ruler to measure the cinder block to get the height of the cinder block. And it's a 12-inch ruler, and there's about 1.5 inches or 2 inches left on the top, and the grass is at the bottom, not even 1/3 of the way up the cinder block. Here's another picture of that trailer with the cinder block with the ruler on it. This as well. This is out. Ruler. So I'm submitting all these. I didn't get a chance to talk about those.
You explained them all already. We heard them.
Okay.
Are there more photographs?
Got more. Oh, wait a minute. Are those the, let me see if these are the color pictures. Yeah, I'm gonna submit these as well. These show the grass and how it was cut, as well as this. Huh? I think so, yes. Thank you.
Thank you. There's just one I want to look at really quick that he brought up.
Oh, I've got other exhibits, I'm sorry, Beth.
Okay.
I've got, an exhibit.
Any objection?
I have no objection.
Bobby, take these into possession for, as evidence
Yes, sir.
when it comes to you.
Okay, I have, Florida State Statute, 705-1015, which states designation of such employees shall not provide the employees with the authority to bear arms or make arrests. And they're talking about code enforcement officers.
Objection, it's irrelevant to this because I'm a sworn police officer in the state of Florida, and the city's ordinances allow me to be a code enforcement officer, and that's already been discussed numerous times, and I believe there's case law on it.
This is not really evidence, Mr. Patzalides. This is, the Code Enforcement Board could take judicial notice of the law. Is that what you want?
Yes, sir, I do, because I got 3 exhibits here, and all of them state that.
Is that law, additional law? Statutes?
Statutes, yes,
Okay.
3 of them, and they all talk about that the code enforcement officer should not bear arms.
Okay, so, we're not gonna receive that into evidence. We'll mark it for that's taken under judicial notice. And so the Code Enforcement Board can read it, but it's not really evidence. So if you could show it to Mr. Gasson first, though, see any thoughts on that. Otherwise, just submit it down.
Is this going directly to you, Mr. Trask, or is it going down?
No, it's, the whole board should see it.
Okay.
It's just not to be considered evidence. It's not like a photograph or affidavit. It's just, it's the law.
Okay, so we're not talking about the other case now, we're just talking about this one, so.
Yes, sir.
Let me save that. Oop. I've got some more pictures, I'm sorry, Beth. These are pictures of the front door, the driveway, and the walkway leading from the driveway to the front door. And more of the side door. Yes, yes, please. This is the definition of curtilage. I'll send that too. May I read that?
I think that my Code Enforcement Board members can read, so there's no necessity to read a document that's
Okay,
being
it's the
tendered into
Fourth
evidence.
Amendment rights of no trespassing.
So that will not be received into evidence. It's only going to be judicial notice. But all the other photographs. Do you have any objection to those photographs, the last ones?
The group that just went through? No, sir, I did not.
Okay. So you're going to need to receive those into evidence, Mr. Chairman.
Yes.
Here, I've got one.
Please receive all this evidence that's coming to you.
Can I ask code board questions?
No,
Do it at the end?
no. You don't ask a judge a question. You wouldn't ask this Code Enforcement Board a question. So the answer is no. You can direct your questions to Officer Gaussen, though.
No objection. No objection to the this batch of photographs.
Okay, I'd like to introduce another exhibit. I hired a lawn service to cut the grass and remove the branch, and they sent me the bill, the invoice, and it shows the dates that they provided the service and did the job, which says July 13th, 2019. I don't know if that pertains to this case or the next case, but I want to introduce that.
I'd object because it's a previous case and irrelevant in this case.
So, Mr. Chairman, you need,
Objection
There's
sustained.
2 dates of service there, the 13th and what, August? August the 3rd. That's under the new case, I think.
so can you show that, please, to Officer Gaussen? Do you have any objection to?
No.
The, I'm sorry, go ahead. Yeah, sorry, Beth. Sorry, you walking back and forth.
Since he's got one that's dated, I don't know what it is, it says August 3rd. I have no objection to it, that he's getting his yard mowed twice a month, so.
We receive that into evidence.
They're on the second page. Lawn care maintenance, 713 and 83.
Anything else, Mr. Patsalides?
So we are going to talk about the other violation, right?
At another time, at this meeting,
Yes, sir. Okay.
another.
I think that's it.
Okay.
Good.
Wait a minute. I want to talk to the tenant now.
Before I talk about anything else, can I say something?
Please.
I can't hear you.
Nobody can.
I have an argument about the documentation that I can't speak for anybody else, but I'm going to speak for me. And there is no changing of stories on my document. What I wrote on that document is what I wrote on the document, and that is exactly the way it was. And I very much disagree with anybody saying that I changed my story if that's the document he's talking about, or if you're talking about.
Do you have anything else you want to say about this situation?
Well, okay, the very first thing of that day was I'm in my bedroom, which is the very first door from the front door. The door was open. The first I heard anything, my granddaughter, who's temporarily staying with me, came down the hall from the back up towards mine, and she says, "Grammy, there's a police officer who said he wants to go in the backyard, and I told him to talk to you." I went to the door. It takes me a while to get to the door. And at that time, is it Gasson?
Yes.
Gas? Okay. Officer Gasson was at the door when I went up there. And yes, we did have a conversation. That was after the fact of him going in the backyard to take the pictures, which I did not give permission to.
Thank you. Does the board have any questions for the respondent?
Okay.
Okay. City staff, any more questions?
Real quick, Ms. Varghese, is that your last name correct, Varghese?
Yes.
Okay.
Call me Sharon.
So, your granddaughter lives there. How long has she been staying there?
Couple of months.
Couple of months. She takes showers, change clothes, to and from work, grocery store from your house?
She's unable to work. She has a developmentally disabled son, and they are staying with me temporarily until she can get services for him.
Okay, so she doesn't have another house?
No, she
Okay.
can't work.
Is your landlord
So-
aware you have her living there?
Well, now he does.
Oh,
I
okay.
didn't say anything about her staying there because she wasn't going to be staying there permanently. She's just staying there until she can get the services that
Okay.
she needs.
Understand. Did you ever tell your granddaughter, when I knocked on the door, your granddaughter came and talked to you, is that correct?
She said, Grammy, there's a policeman that wants to talk to you about taking or going into the backyard.
Right,
And so I went to the front door, which it takes me a little while to get there.
right.
But when I got to the front door, you were already standing at the front door. I opened the door, and that's when we spoke.
How long do you think that was from your granddaughter? Because you weren't around when I knocked on the door and first spoke to your granddaughter, were you?
I was close to the front door if you knocked on the front door.
I knocked on your front door?
I'm saying if you knocked on the front
Oh.
door,
Well, the door I knocked on where your granddaughter answered.
the back door, yes.
Okay. So you didn't hear any of my conversation with her?
No,
Okay. So you never said, don't let him go in the backyard, right, to your granddaughter?
I said that I would ask the landlord's permission to let someone go in the backyard if they asked.
Did you ever say that to me when we spoke?
No, because you had already gone back there.
But you never said that. You never told me you wish you, and anything in the negative, basically. What did you tell me about the, how your landlord treats you? Do you remember that conversation?
I don't recall anything about how
let's
he
talk
treats
about,
me.
well, let me ask you a really quick question. Did you talk about the air conditioning with me?
What
What did you say about the air conditioning?
about the air conditioning? I just got a new air conditioning unit
Right.
in there.
Okay. Do you remember I said to you, how is your landlord? You remember that conversation?
Might I have mentioned a hole in my ceiling?
Well, you also mentioned the fact you've asked him to fix your plumbing, and he doesn't do that, but he's great at fixing the air conditioning. You remember that conversation?
I did say.
Oh, okay.
I
All
did
right.
say that he is always promptly taking care of the air or the heat.
Right, but not so much the plumbing.
Uh,
Is that the conversation?
I don't recall a conversation, but yeah, I do have a plumbing problem and he hasn't taken care of.
Okay. And in the backyard, is there, did you see the photographs at the very beginning that I had taken?
I'm sorry, repeat that?
Did you see the photographs at the very beginning that I took?
I saw them when Mr. Patzalides showed me the pictures that he
Okay.
had taken in the backyard.
Is that your backyard at the place you live at?
Yes.
Okay. Is those things that are in your backyard there? The pipes, the white PVC pipes, the screen leaning up against the back of the building, all the items behind the shed, in between the shed and the back fence, are all those things there?
A lot of them have been taken away. It's not a discarded screen, by the way. It's a screen that I took over there to put on that window, but
Okay.
couldn't manage it, and I still need to go back
Well,
there and do it.
was it there sometime between July 15th?
Yeah, it was there.
Oh, okay.
And it's still leaning up under the leaning up to the house under the window that
Oh, okay.
I wish to install it into.
Okay. And we did establish you had a handicap, right? Your mobility handicap, maybe to the
Everyone
extent.
under my roof.
Okay.
Not my great grandson is, but my husband, myself, my son, and my sister are all disabled, and I am the most capable amongst us.
Oh, and you're responsible to do all the lawn maintenance and taking care of all the debris at the place you rent from Mr. Patzalides, correct?
Yes, and my son was helping with that. He has orthopedic problems, but he now has more orthopedic problems, and he has not been able to keep it up. In the meantime, now Mr. Patzalides has a yard service coming and doing it.
Oh, so once he was kind of aware of the problems, then he decided to hire somebody to take care of these problems?
With the code enforcement issue,
Oh, okay. I have no
Favor?
further questions.
Okay, we can close the public hearing.
We can go ahead and close the
Oh,
public hearing now. I'm sorry.
Oh, I'm sorry. But I just wanted to say that I didn't talk to, and I refer to him as Harry, it's hard to call him Mr. Patsalides. I didn't talk to Harry about the issues that I talked to you about the plumbing.
Okay.
And
I have a real quick question for Mr. Patsalides,
yes.
if I could.
yes,
Mr. Patsalides, is your email address Harry Patsalides at, was it gmail.com or email.com? I can't read it up here. Is this your email you sent or you received from Beth? And you sent on July 14th from Harry Patsalides at gmail.com, code enforcement, and you sent some pictures. Is this yours? Would these be pictures you took of your backyard at 385 Wickham? Are those yours?
That one is, yeah.
Okay. So that one is, all right, hang on 2 seconds
Well,
then for me real quick.
I don't
Oops.
remember you taking pictures in the backyard while the tree was down.
I have another one. Okay, so sorry about the upside downness. That's how it was emailed to me. Is this from Harry Patsalides at gmail.com sent to all code enforcement, which go to me, Beth, Bonnie, and my Sergeant Fogno. Are these pictures you took of your backyard?
I can't even see it.
Oh, how about this? Is that one a little better?
Yes, sir, that's good.
Okay,
It
so that's the
shows
same
grass-
one I gave you earlier, right?
Grass is cut, shows no branch.
All right, I don't argue with your grass or your branch.
Well,
So, but it is your backyard, right? That's your trailer, and we'll get past the grass pictures because they're kind of movable. Oh, wait, there's the branch.
Yeah.
Oh, and there's the shed. Okay.
Yeah, I
Okay.
didn't send those pictures.
Well, they're from you. Isn't this your screenshot from your phones from Brian Grass and Tree saying, we'll do tomorrow, thank you very much, and you sent it to us?
That was the tree service that cleaned it up. They sent
Okay.
me the documentation.
You didn't send us
showing
that picture.
they cleaned it up on July the 13th when I gave you that invoice. or
Did you
July.
email us those pictures? Did you email those
I
pictures to us?
forwarded those from the tree service, from the
Oh,
lawn
okay,
maintenance
I must have missed the forwarding in here
Shows
somewhere.
that we cleaned it up prior to the deadline.
That's fine. I just,
July
those
15th.
were the pictures that we presented to you earlier that you alleged they were my pictures. So those all came from your email that you sent us. So I just wanted to establish with the board that those were all your photographs that you sent to us regarding your property.
You asked if I took them, and I told you I took some
Okay.
and didn't take the
Okay, we can-
others.
Okay, that's fine.
We're gonna-
I have no further questions.
We're going to close the public portion of this case now. And I'm going to ask the board to,
Wait a minute, I haven't closed yet. I haven't had a chance.
do you want to summarize?
Yes, sir, I appreciate it.
And I would like an answer to my
Ma'am, you're a
disagreement
witness.
to
Ma'am,
my.
Just a witness.
you're just a
document.
witness, so Mr. Patsalides, if
Go
you're able
ahead.
to close it.
Okay, I don't know if you heard, but Ms. Voorhees told me, I think she's got a low voice, but she said that she did not bring the plumbing issues to my attention, and therefore I wasn't aware of it. But she also said anything that she has brought to my attention that I responded and repaired to timely.
Okay.
Officer Gasson has basically systematically gone from property to property, and I've provided a prior complaint to his supervisor with a video showing he trespassed on the property. He said he got permission from one of the tenants. I got submitted affidavits from all the tenants stating that they didn't give him permission. I haven't heard anything from his supervisor, Sergeant Fogno. The last time I asked him, he said he sent it up the chain, but I haven't got a response back to that complaint. So he's got a history of trespassing on my properties, and that's why I presented before this board a directive to him not to trespass on the properties. Clearly, from those pictures, he trespassed on the property. There's a front door with a driveway and a walkway to the front door. Miss Voorhees was right next to the front door. If he'd have knocked on the front door, he would have talked to the tenant He tried to circumvent that by going to the back door, to the side patio door that was behind a wall where he had to cross the grass. He didn't walk on the front steps or the driveway like any normal person would. That to me does not sound like somebody who's just trying to create compliance. It sounds like somebody who's trying to find me and has targeted me for all these violations. I've told you in the past that I'm compliant. All somebody has to do is tell me what to do and I do it. But once he made me a repeat violator, it continued after that to get fine after fine after fine. I think I've presented sufficient evidence to show that he trespassed on the property, even though you did not sustain my objection. The evidence that I submitted clearly shows his intentions, that he wasn't intending to monitor, go back to view what needed to be done, because that was all on the outside. There was no reason for him to go back in the backyard. He could see everything from the outside. He went there strictly to create a new violation and to continue this, basically what I think is harassment, bringing me to the code board. I like you all, you all seem to be nice people, but I don't want to see you every month, yet that's what appears to be happening. Ms. Voorhees was here before. He knew who she was. He knew she was the tenant. He didn't knock on the front door. He purposely knocked on a patio side door behind a brick wall that he had access through the grass in order to try to circumvent the process. And I do not believe that I should get fined on this property. The property is in compliance now. The lawn maintenance service has done everything that's pictured, I guess, here. Everything is in compliance. So I just don't believe that this should continue on like it is. And I think I will submit, I think formally, another complaint to a supervisor regarding this situation.
Okay.
Do you have anything?
She's just the witness, sir.
Get to summarize your case.
Summarize your case.
Okay, well, she has testified that she did not give him permission to go on the property. She submitted an affidavit under oath before a notary, and if I'm presumed innocent until proven guilty, like I'm supposed to be, the evidence clearly weighs in my favor of dismissing this case or not finding me in violation based on improperly obtaining the evidence.
I'm closing the public portion of this case, and I'm asking the board to get ready, and I will entertain a motion. Do you have any suggestions for time? And
It's a repeat violator, sir.
Violator.
And I still have it as, our office hasn't been notified he's in compliance yet for me to conduct an inspection, so it's still open as required by law.
Thank you.
I move that based on the testimony, evidence, facts presented, and law, that the respondent, Harry Patsalides, was in violation of sections 840 and 852 of the Tarpon Springs City Code from July 15th as to such time as this property is brought into compliance, and a fine of $75 per day shall be imposed until compliance is met. In addition, I move that the city be awarded $69.50 for the costs incurred in prosecuting this case.
Can I have a second, please?
Second.
Discussion? Bobby, roll call?
Mrs. Tellier?
Yes.
Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
No.
Mrs. Dabbs? Ms. Wade?
Yes.
Mr. Weeks?
No.
Carried
carries
4-3.
Mhm.
Okay, so Mr. Petzler, the property, you as a property owner have been found in repeat violation of section 8-40 and 8-52. There is a fine running at $75 a day. It began on July 15th, 2019. The Code Enforcement Board also awarded $69.50 in prosecution costs. You get the order in approximately 10 days in the mail. Okay?
Mr. Papalides, I want to tell you that I appreciate you coming every time, and I appreciate you bringing witnesses and having the go-to to take all the time to be able to present your case. I also want to suggest that perhaps you have something that Officer Gasson has done to you that has really angered you, and I'm sorry that happened.
I think it's the other way around, sir.
Thank you very much.
Thank you.
Okay, next case.
Next case.
We do his other one.
No. Yeah, why not? You don't have to leave. We're gonna do number 17 next, and 19-8000396, 385 Whitcomb Boulevard, Harry Papalides.
Oh, non-compliance.
Repeat violator.
This is an affidavit of compliance that's being submitted.
Oh, it's an affidavit of compliance? Oh,
You have that affidavit?
I'm getting there.
Okay. You have it, Beth?
Oh, they're all stacked in here.
Here's the
This is just need a motion to accept the affidavit of compliance then.
Do I need the dollar amount?
No, you just need to accept the affidavit of compliance. It's in compliance.
Okay.
So you're not, there's no finding of a compliance date, there's no finding of a fine. It's just confirming that the property's in
He did.
compliance. And they're saying the property was in compliance as of July 13th.
Yes.
I'll entertain a motion.
I move that the affidavit of compliance be accepted in case number 19-8000396.
That's not it. Did I get that? I'm on the wrong page. I apologize. You're correct. I'm looking at the other case.
We can't hear you down here, whatever you're saying.
So I was questioning the case number, and I was looking at the first case number on the agenda. And so I was just letting Mr. Kramer know that I was mistaken as to him citing the wrong case number. He's got the correct case number. His motion is to accept the affidavit of compliance.
Second.
All those in favor?
Aye.
All those opposed, same sign?
Do I get a chance to talk about this?
No.
No.
Motion passed. Thank you, sir.
As you led me to believe I shouldn't have turned in some of my exhibits earlier because we had another case. And now you're telling me I can't speak or turn in my exhibits. So I still have one more exhibit that I was saving that I want to turn in.
You're in compliance. What are you fighting?
Well, the date of compliance, sir. You got me in
13th.
compliance as of July 13th, but I was in compliance as of June 17th. So it deals with the fines and the amount of the fines. So let me submit this, please, if I may.
You can do a fine reduction
You go
request.
by and find that it's in compliance, correct?
That
What
one was a
date
repeat.
that?
I don't have that information on that case in front of me. It was a repeat violator case, and I conducted the inspection
Done.
when we're told to, because if you don't contact our office as required by law, I don't randomly check those.
Exactly.
And then,
Okay, so,
Yes.
um,
and it's the same
I
date as
did
the invoice.
notify his office.
Great.
okay, so I want to back this up just a little bit. If there is evidence that it came into compliance prior to the date that Officer Gasson has determined to be in compliance, that's something that you need to consider because there is a fine associated with it. So we need to address that right now. So if you have additional evidence, I'm going to provide these two affidavits to Officer Gass and let him take a look at that. You said you had another piece of evidence?
Yes,
Okay,
sir.
he needs to see that.
And also, the lawn maintenance service shows the 2 dates that they conducted the lawn, cleaning up the lawn, cleaning up the yard, and a bill of $300 for that.
In that last case you're referring to, correct?
Yes, sir. But it also it talks about this case and when they did it,
Okay, Bobby, can you pull that out and,
which is before the date that you guys just talked about.
7/13.
so, can you just pull that piece of evidence out and let each board member look at that as it comes back this direction? We're talking about the one about the lawn service.
Lawn service wasn't
There's an invoice for it in there.
Invoice that went down that
But Mr.
direction.
Patsalidas testified that it was
Yeah, it was
completed
yellow
seven-
highlighted. There was 2 pages, yellow highlighted,
That's
something
fine,
lawn
too.
care.
You said it was, I wrote it down. You said it was completed on 7/13. He was suggesting
God.
7/15, and he's agreed if you want to make it 7/13, that was okay. That was your previous testimony. And then we said, you're on the wrong case, Mr. Patsalidas, but I still had made notes that you said that.
Yes, 7/13 is when they went back to clear up this current, or the prior one.
Correct.
That's the date of compliance. And that photograph is from July 10th. So July 13th was the date, and it's on the lawn maintenance invoice. And we discussed it last code board.
Okay.
Right, and you can see that the grass is not over 12 inches, and I submitted exhibits measuring those yellow poles and also showing where they're situated right on the corner when the majority of the
Okay,
lot
Mr.
was.
Patsalidas, we had that case, and you were found in violation
Exhibit.
on that case.
Frank, Frank Trask, did you still want to see this? You want each board member to see it?
Yes, yeah.
Yes, okay.
I'm sorry.
Keep going. Bring it back. Try- Just trying to make sure we know the flow. We're doing good.
So-
Last month.
Yeah, Mr. Patzali previously testified it was in compliance as of July 13th. The affidavit of compliance says it's in compliance as of July 13th.
Yes.
And so you've considered the appropriate testimony and evidence. You've already accepted the affidavit of compliance. At this point, I think that we can go ahead and move on. Is there something else you wanted to
Yes,
proffer
sir.
in evidence?
Yeah.
What is
Um,
that?
The affidavits state that 90 to 95% of the yard was cut in the prior case. And here's a statute from Pinellas County Codes,
You don't
Section
need that.
58.
This isn't Pinellas County, so
I know, but it states that
It doesn't
the
matter what it
majority of the
states.
property, if it's cut, complies. So I want to submit that.
So that will not be received into evidence. We'll go ahead and proffer that into evidence. I'll mark that as being proffered, but it's not evidence, Mr. Patzalides.
Okay.
Okay, the board has already ruled on this, so.
Let's go ahead and go to number 4.
Before we move on, could I just have the evidence that?
Yep, we're gonna
Yes,
pass
I
this
have some
back.
here as well.
I'm gonna bring it down.
It's fine, I just don't want to.
I was handed that
Pass it.
by Mr. Trask.
Okay, I need those 2 affidavits.
Yeah, they're in this packet coming to you right now, Tom.
I got it. And where do these photographs come from?
Hang on. I'm going to have a recess for 15 minutes. Anybody wants to go to the restroom?
Okay.
I'm sorry, you're making a recess. Okey dokey.
What'd you need? Were you just hanging out? Oh, you're more welcome to then. All right, I'm going now. What?
Okay, so we're just waiting for Officer Gasson to return. And here he comes. So we need to open the meeting back up.
Awesome.
And he wanted, he said he knows.
Sorry.
Code Enforcement Board will come to order.
Just to finish up from the last hearing, I want to let you know that I have provided the Code Enforcement Board clerk the documents that had been presented by Mr. Patsalitas. The board has considered and approved the affidavit of compliance. There's nothing else that you need to do on that particular case. So we can move on to your next case.
Okay, the next case is number 2. No, I'm sorry.
Where
Got it. Number 4 on the first page, 19-800000435, 1313 Gulfview Woods Lane. Faith Senveris. Anybody here on that case?
No, there's not.
Go ahead.
Thank you, Officer Steve Gasson, City of Tarpon Springs Police Department Code Enforcement. Case number 19-800000435. Property address is 1313 Gulfview Woods Lane. Faith Sedaris is the listed property owner. Exhibit number 1 going before the board are all the photographs. Exhibit number 2 notices a violation and notice of hearing. And exhibit number 3 is administrative documents, case summary, property appraiser, and tax collector records. Exhibit number 4 is the affidavit of posting and a copy of the sign. All the notices were mailed to the property owner of record as determined by the Pinellas County Property Appraiser and Tax Collector databases. All notice of violations and notice of hearing are sent return receipt as well as first-class mail. And please accept these exhibits into the record as evidence, Mr. Chairman.
Bobby, when they come down to you, please do so.
Yes, sir.
This case started on July 1st of this year. There was a complaint from a neighbor about a vehicle under a car cover that appeared inoperable. No right front tire. There's a pile of wood and bricks in front of the garage on the west side. Fence on the east side gate was damaged and in poor condition. On July 2nd, a notice of violation was mailed. It was returned unclaimed. On July 18th, I conducted a reinspection. There was no change. At that point, we determined to send it to the board. On July 29th, the notice of hearing was mailed. It was returned, signed. Property was posted on July 29th, and the affidavit was signed. On August 7th, I conducted a final inspection. And there's actually an included photograph for August 7th. They were not in compliance. They had done some work, and obviously it was a work in progress at the time. So at this point, the board, or the city would like the board to consider a violation of 40.00, parking, storage of abandoned vehicles. The silver PT Cruiser, when I conducted the reinspection, initially it was under the cover. You could see the right front tire was missing. And then on one of my photographs from 8/7, there's no license plate on the vehicle. So I didn't have anything to run. So it's in violation of a 40.00 for both inoperability and it's not registered. Also, city codes, 8-22 accumulation of trash, and then 36.03, which are fences, walls, and hedges, which require them to be maintained and kept in good condition. I will add, I guess the property owner was here and he just couldn't stay. So he had a request, and if you'd like, it has to do with his time frame, and I can give that to you at the end, or if you want to hear it now, it's your choice.
Great.
Okay.
Oh, sorry, he said he should have everything done. If he could just have 3 weeks, he should have everything done before that. So, but he doesn't argue. He's, like I said, when I drove by yesterday, the mower was out in the yard. You can see that one of the pictures. He's cleaning stuff up and he's working on it. So, it's obvious he's intending to get it done.
Any other questions from the board?
The date you're using for the,
I'm sorry?
the date, I didn't catch
I
that.
started the case July 1st.
Okay, so, close the public portion of this, and I would entertain a motion.
Sorry. I move, based on the testimony, evidence, and facts presented in law, that at the time of the alleged violation, Sections 8-22, 36.03, and 40.00 of the Code of Ordinance of the City of Tarpon Springs was in force and in effect, the respondent was in violation thereof.
Second.
We need a roll call, Bobby.
Mrs. Telliar?
Yes.
Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Yes.
Mr. Creamer?
Yes.
Mrs. Dabbs? Ms. Wade?
Yes.
Mr. Weeks?
Yes.
Motion carried.
I move that the respondent shall have until September 4th to bring the property into compliance with Code Sections 8-22, 36.03, and 40.00, or suffer a fine of $25 per day for each day thereafter the respondent remains in violation of said code section.
Second.
Roll call, Bobby.
Ms. Telliar?
Yes.
Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Mrs. Dabbs? Yes. Ms. Wade?
Yes.
Mr. Weeks?
Yes.
Motion carries.
Number 6, 19-800000439, 649 Kenneth Way.
There's nobody here on that case either. Officer Steve Gasson, City of Tarpon Springs Police Department, Code Enforcement, case 19-800000439. The listed address is 649 Kenneth Way. It is a vacant lot owned by Nikitas and Nicoletta Cavacles. The parcel is 10/27/15/31482 0050020. We've had no contact with the owner. All the photographs are exhibit number 1. All my notices of violation and notice of hearing are exhibit number 2. Exhibit number 3 are administrative documents, case summary, property appraiser, and tax collector records. Exhibit number 4 is the affidavit of posting and a copy of the sign. All my notices are mailed to the property owner of record as determined by the Pinellas County Property Appraiser and Tax Collector databases. All notice of violations and notice of hearings are sent, return receipt requested, as well as first-class mail. And please accept all these into the record as evidence, Mr. Chairman.
Thank you. Bobby, when they get down to you, please
Yep.
accept them into evidence.
As I stated, we've had no contact with the owner. I started my inspection on July 2nd of this year. The property was overgrown. The notice of violation was mailed. There was no mail return, and the United States Postal Service tracking shows that it was unclaimed. On July 18th, I conducted a re-inspection. The property was still overgrown and had not been maintained. At that point, the decision was made to send a code board. On July 19th, the notice of hearing was mailed, no mail return, and the United States Postal Service tracking shows that the delivery was attempted. On July 26th, posted the property and an affidavit of posting was signed. On August 7th, I conducted the final inspection. You can see in the photographs, it's still not in compliance. The grass was mostly mowed. There's cement pieces on the property. There was some garbage in bags on the property. Grass around some of the tree stands hadn't been mowed and was still grossly overgrown. And there's other debris still towards the back of the property. So the property is still in violation of City Codes 8-40 and 8-52. And the city has nothing further.
Thank you. Does the board have any questions for the city staff in reference to this?
Recommendation as far as time frame?
We can't hear you. You need to.
What would be your recommendation?
If you want, I can give them now. There's no prior cases from them, so I would say what's left,
So nothing,
they have just some cleanup still left to do. So I would say no more than 30 days and $25 a day for the fine.
If nobody's picking up this mail, how do they know that?
Somehow they got the property cleaned up. We've found that sending it also by first-class mail and not return receipt, some people are just a little bit freaked out about signing for a certified letter. So, but they have a tendency to read the first-class mail and they figure it out. Or they could have noticed the posting as well when we stuck the sign in the yard. So
Okay.
I can't tell you how they figured it out, but they seem to.
or somebody told them,
Or somebody told them.
right? To go by.
Close the public portion of this case, and I'll entertain a motion.
Should we wait for the evidence to get all the way down?
Oh, that's a good idea. I'm sorry, I
Not
didn't.
that I'll disagree, but I'd like to take a look.
Thank you, sir.
I will now entertain a motion.
Right,
Go ahead.
make the motion.
Got it down here?
I move that the evidence, I move based on the testimony, evidence, and facts presented in law that at the time of the alleged violations, sections, I just lost my place. The top, 8-40 and 8-52 of Code Ordinances of the City of Tarpon Springs was in force and effect, and the respondent was in violation thereof.
Second.
Roll call, Bobby.
Mrs. Telliar?
Yes.
Mrs. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Mrs. Dabbs?
Yes.
Ms. Wade?
Yes?
Mr. Weeks?
Yes. To number 7.
We need to finish the second half of
Second
this
motion.
motion.
I move that the respondent shall have until 30 days, September 10th, to bring the property into compliance with code sections 8-40 and 8-52, or suffer a fine of $25 a day. Thereafter, the respondent remain in violation of said code section.
Second.
Roll call, Bobby.
Mrs. Telliar?
Yes.
Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Mrs. Dabbs? Mrs. Wade?
Yes?
Mr. Weeks?
Yes.
Motion carries.
Number 7. 19-800000448. The vacant lot on 510 Wideview?
South of 510 Wideview.
South of, oh, I got it.
More for me. Officer Steve Gasson, City of Tarpon Springs Police Department Code Enforcement, case 19-800000448. This is a vacant lot south of 510 Wideview. It doesn't have a city address. It's owned by Jonathan and Olga Pappas. The parcel number is 112715-87876-015-0100. Exhibit number 1 going before the board are all of my photographs. Exhibit number 2, all notices to include notice of violation and notice of hearing. Exhibit number 3, administrative docs, case summary, property appraiser, and tax collector records. Affidavit of posting is exhibit number 4. All my notices are mailed to the property owner of record based upon the Pinellas County property appraiser and tax collector databases. All notice of violations and notice of hearing are sent return receipt as well as first class. And Mr. Chairman, please accept these into the record as evidence.
Bobby, when they come down, please accept them into evidence.
Yes, sir.
This case started July 2nd. We have had contact with the owner, both via phone call and email. They've been fairly respondent. While I was conducting inspections in the area, I noted this property was overgrown and there is debris dumped on it in the form of tree branches. On July 3rd, the notice of violation, notice of hearing was mailed. It was returned signed to our office. On July 9th, I conducted a reinspection and the property was in compliance. On July 26th, I posted the property and an affidavit of posting was signed. I would like the city to establish this property for violations of 8-40 and 8-52 based on the priors that have occurred at that property. I'm hoping that there won't be any further, and that's all the city has at this point. They are in compliance.
Close the public portion, and I'll entertain a motion.
I move based on the testimony, evidence, facts presented in the law that at the time of the alleged violations, sections 8-40 and 8-52 of the Code of Ordinances of the City of Tarpon Springs were in full force and effect. At the time of the notice of violation, the respondents were in violation of said code sections. However, they are now in compliance.
Second.
Roll call, Bobby?
Ms. Telliar?
Yes.
Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Ms. Dabbs?
Yes.
Mrs. Wade?
Yes.
Mr. Weeks?
Yes.
Very good.
Now, the second part?
No, that's it.
No, it's,
No,
Second
not
part.
sorry
needed.
about that. Number 10, 19-800000470 to be established, 715 West Bay Shore Drive.
Officer Steve Gasson, City of Tarpon Springs Police Department Code Enforcement. This is case 19-8000470. The property address is 715 West Bayshore Drive. It's owned by business Averex LLC. Exhibit number 1, going before the board, are all my photographs. Exhibit 2, notice of violation and notice of hearings. Exhibit 3, administrative documents, case summary, property appraiser, and tax collector records. And exhibit number 4 is the affidavit of posting and a copy of the sign. All my notices are mailed to the property owner of record as determined by the Pinellas County Property Appraiser and Tax Collector databases. All notice of violations and notice of hearing are sent return receipt requested as well as first class. And Mr. Chairman, please accept these exhibits into the record as evidence.
Bobby, when they come down to you, please.
Yes, sir.
This case started on July 12th. We got a citizen complaint regarding the property being overgrown. There was also a pile of debris, tree debris that was curbside, partial pallet of bags of sand or cement at the end of the driveway. We have had some contact with the owner, both via office visits and emails, owner being a business. On July 12th, the notice of violation, notice of hearing was mailed. The mail was returned undeliverable from the registered agent, but it was delivered and mail returned vacant for the owner. On July 26th, I posted the property and signed the affidavit of posting. Also on July 26th, I conducted the final inspection. And I had, originally, I had emailed the office and the property is in compliance as of now. So that's why it's before the board to be established. So it is in compliance of 8-22, 8-40, and 8-52 of the city codes. One of the reasons why I brought it before the board to be established, just so you understand, is a few months ago we had a code board case on this exact same property for permits. And that case is still open and ongoing. So that was the reason why they're being established, because I kind of don't know what the status with this owner is. So if they go into violation again, they'll be a repeat violator at that point, and hopefully we'll be able to keep it in line. They did tell us they thought it was being sold, but we've seen no change in the record according to the property appraiser or the tax collector. So that's why we're here. But as it is, it's all in compliance as of now.
It's a public portion, and I'll entertain a motion.
I move based on the testimony, evidence, facts presented in the law that at the time of the alleged violations, sections 8-22, 8-40, and 8-52 of the Code of Ordinances of the City of Tarpon Springs were in full force and effect. At that time of the notice of violation, the respondents were in violation of said code sections. However, they are now in compliance.
Second.
Roll call, Bobby?
Ms. Telliar?
Yes.
Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Mrs. Dabbs?
Yes.
Mrs. Wade?
Yes.
Mr. Weeks?
Yeah. Now we're good. What?
Case 13. Yeah, we skipped over, I'm sorry.
Case 13, repeat violator, 19-8000511, 418 South Levi's Avenue.
And there's nobody here for that address either. This is a repeat violator from July 24th of this year, and it's still in repeat violator status. It is not in compliance. It's a repeat violator for case number 18-800000386, which is a violation of City Code 8-40 and 8-52. That one was a prosecution-only case. There was no fines. They came into compliance. I'm Officer Steve Gasson, City of Tarpon Springs Police Department Code Enforcement. The case before the board is 19-800000511. Property address is 418 South Levis Avenue. Emma Scott Murray is the listed property owner. Exhibit number 1 going before the board are all my photographs. Exhibit 2, notices of violation and notice of hearing. Exhibit 3, administrative documents, case summary, property appraiser and tax collector records. Exhibit 4, affidavit of posting and a copy of the sign, and Exhibit number 5 is the affidavit of prosecution costs. All the notices are mailed to the property owner of record. It's determined by the Pinellas County Property Appraiser and Tax Collector databases. All notice of violations and notice of hearing are sent both return receipt as well as first-class mail. And, Mr. Chairman, please accept all these exhibits into the record as evidence.
Bobby, when they come down to you, please.
Yes, sir.
We've had no contact with the owner. This case started, as I stated, on July 24th. There's a large amount of trash and debris outside of the house, and it is a repeat violator. On July 25th, the notice of violation, notice of hearing, and a repeat violator notice of hearing were mailed, and the mail was returned signed. Just for the board's information, the property wasn't posted. We just had a clerical error, and we didn't get a sign in the yard, but we did get back the green card signed by the property owner that they received the notices. On August 7th, I conducted a final inspection, and there was no change to the property. What's before the board is a violation of City Codes 8-22, 8-40, and 8-52. It should be noted that 8-22 is a new violation and is not part of the repeat violator. But it is, like I said, none of them are in compliance. So 8-22 is new, and 8-40 and 8-52 are repeat violations, and none of which are in compliance at this time.
But prosecution costs only.
But that was the previous case. All that basically is, it came to the board, they came into compliance, but it was heard by the board to be established, and this board found prosecution costs, and those have been paid on the case, but there was no fines levied on that previous case. And as you can see by the photographs, it's, you know, we got it into compliance once, and it's just developing again. And that's all the city has at this time.
Close the public portion. Does the staff or does the board have any questions of Officer Gass? Okay. Entertain a motion.
Okay, my suggestion, this is gonna be like several motions.
Yes.
Do the double motion on the new violation and then another motion for the repeat violations, which would include the affidavit prosecution costs when you do the repeat portion of it.
Okay. I move based on the testimony, evidence, and facts presented in law that at the time of the alleged violation, Section 8-22 of the Code of Ordinances of the City of Tarpon Springs was in force and effect, the respondent was in violation thereof.
Second.
Roll call.
Mrs. Telliar?
Yes.
Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Mrs. Dabbs?
Yes.
Mrs. Wade?
Yes.
Mr. Weeks?
Yeah.
Then we need a second motion on the, for that one.
Well, you need the
I'm-
second half of the first
that one.
motion.
I understand. I move that the respondent shall have until September 4th to bring the property into compliance with Code Section 8-22 or suffer a fine of $50 per day for each day thereafter the respondents remain in violation of said code section.
Second.
Roll call.
Roll call.
Mrs. Telliar?
Yes.
Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Mrs. Dabbs? Mrs. Wade?
Yes?
And Mr. Weeks?
Yes.
Please roll call.
Then, as I understand what you said, the repeat violations are still non-compliant, is
That is
that
correct.
correct?
From July 24th.
July 24th?
But there was no fine assessed at that
There's-
time, just prosecution costs?
That was the last case.
Yeah.
Oh.
Okay. I move that based on the testimony, evidence, facts presented in law, that Emma Scott Murray was in violation of sections 8-40 and 8-52 of the Tarpon Springs City Code from July 24th of this year until such time as the property is brought into compliance, or a fine of $50 per day shall be imposed until compliance is met. In addition, I move that the city be awarded $91.50 for the costs incurred in prosecuting the case.
Second.
Roll call, Bobby?
Mrs. Telliar?
Yes.
Ms. Norfleet?
Yes.
Mr. Robinson? Mr. Kramer?
Yes.
Mrs. Dabbs? Mrs. Wade?
Yes.
Mr. Weeks?
Yeah.
Motion carries.
Move on to case 14.
Number 14 is 19-800000317. It's a vacant lot on Lincoln Avenue. Craig Fowler Jr. owns it.
And this is an affidavit of noncompliance. There's no one here in the audience for this case, so you can just need a motion to accept the affidavit of noncompliance.
I move we accept the affidavit of noncompliance in that case and award the city $171 prosecution costs.
Second.
All those in favor, say aye.
Aye.
All those opposed, same sign. Motion carried. Affidavits of compliance. Number 15. 15-200000006. 4839 US Highway North. Lake Tarpon, Church of Christ.
I move we accept the affidavit of compliance in that case. That's it.
Need a second.
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 Okay, roll call, please. I'm sorry. All those in favor, say aye.
Aye.
All those opposed, same sign. Thank you. The next one, 17-800000544.
I move we accept the affidavit of compliance in that case.
Second.
All those in favor, say aye.
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 Opposed, same sign. Motion carried. Okay, now old business. Fine reduction request. 16-80000000007.
Yeah, this being a fine reduction request, you're to review the petition and make your determination based solely upon the written petition. There's a significant package that you have here. In addition to that, there's the city's response.
This is interesting.
I'll entertain a motion when everybody's done.
I'm ready if you are.
I am.
I move in the case 16-800000007 that we do not accept the request for reduction of fine.
Second.
All those in favor, say aye. Oh,
Question?
yes.
Discussion.
Yes, ma'am. Discussion. I apologize.
What would happen next if we deny it? What happens to, is the property foreclosed on? Is that something you can answer?
Well, I'll answer that. So the answer to the question is that the fine would remain, after 90 days passes from the date of the recording of the fine, then the city could begin collection procedures if it wanted to. But the lien would remain on the property for 20 years unless the city decided to foreclose the property. If it is homesteaded property, it would not be foreclosed. The lien would just sit there. Under the Florida Constitution and under Chapter 162 of the Florida statutes, the city is prohibited from foreclosing on properties that are homesteaded properties. So taking what this is saying for to be the truth, and these people are living there, it would be homesteaded property, and therefore we'd not foreclose it.
On the city's comment sheet, it said no one lives in this home.
Okay, so it still could be considered homesteaded property, even though someone's not living there. We would make that determination, but that really shouldn't be something that you should consider in what you're doing here. You're to determine based solely upon this petition and the response, does it meet your requirements of your Rule 5, Section 4? And I could read the whole thing, but it basically, you're to find either that there's an undue hardship, or there's something that prevented the violator from coming into compliance within the time that had been previously ordered. So if you find that either one of those situations exists, then you could grant the petition. Right now, the motion on the floor is to deny it.
And these are the people that came last month?
No,
when
this
were
is
they-
not the people that came last month.
Okay.
That was a different property.
Okay.
Any further discussion? I think I want a roll call, Bobby.
Oh, okay. Mrs. Deliar?
Yes.
Excuse me. Ms. Norfleet?
I want to make sure I understand the motion. It's to deny the petition, correct?
Correct.
Correct.
Yes.
Okay. Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Mrs. Dabbs? Ms. Wade?
Yes.
Mr. Weeks?
Yes.
Motion carries.
Thank you. Petition to reconsider 18-800000869, 707 Chesapeake Drive.
Okay, so I want to read this rule to you. We don't hear these types of petitions a lot. This is not a petition for fine reduction. This is a petition to reconsider. I want to read that rule to you. So this is Rule 5, Section 3 of your Rules of Procedure. They've been in effect for almost 30 years, I think. I'm going to read it word for word. Any aggrieved party may petition the board to reconsider or rehear any board order resulting from public hearing. This petition must be made in writing and filed with the board secretary no later than 30 days after the execution of the order and prior to the filing of any appeal. Upon receipt of the petition, the board will consider whether or not to reconsider or rehear the case. A motion to approve a petition to reconsider or rehear must be made by a board member who previously voted on the prevailing side. A motion to approve a petition to reconsider or rehear a case must set the date and time for the rehearing. The rehearing may be held at the time of the consideration of the petition if the petitioner and all other parties agree, and the board will not hear oral argument or evidence in determining whether to grant the petition to reconsider or rehear. So having read that rule, your options are to grant it, and if you grant it, then what would happen is you would determine whether you're going to hear the case today or you're going to hear it sometime in the future, for example, next meeting. Your second option would be to deny the petition to reconsider. When I read this petition, it looks to me what she's really looking for is it's really not a petition to reconsider. It's really a petition for extension of time. You could also do that today if you wanted to decide to change your previous order and extend the compliance date. That would be another option. So,
Does some reason have to be provided? I mean, some kind of documentation that would make us open it, or?
well, it's this letter that actually it's an email from Tina Hinton It was dated Monday, July the 8th at 2:09 PM. It was directed to Beth Hughes. The subject is Code Enforcement Board petition to reconsider. And then there is the statement in the email. Does everybody have that, or should I just read it out loud? Everybody have it?
I don't have it.
No?
I can't find it. Yeah.
All right, I'm going to read it out loud. This is what it says. Case number 18-800000869. This is a request
There it is.
for time to comply with the code enforcement orders on 707 Chesapeake Drive, Tarpon Springs, Florida. There has been an extensive amount of work completed at the property. There is 2 more dump truck loads of yard debris, pepper trees, that have been removed and will be hauled off. There has already been 15 dump truck loads removed. The house has been sealed and is ready to be painted after the roof is installed. The outstanding work that remains is contracted with Contos Roofing and Construction. I am at the mercy of their schedule. And then it's signed Tina Hinton.
Can you refresh our minds as to, I thought she had the livestock.
She has a couple of cases. This one was heard by this board February of this year, and this board gave her a compliance deadline of May 23rd. So since May 23rd, she's actually been running daily fines on this property. So she's 3 months, 90 days past that. Almost 90 days. And the case started November of 2018.
Oh, yeah.
You really didn't say how much time. You said time.
You
Didn't
have,
we already give
yeah,
her
you have what I have.
Didn't we already give her a petition to reconsider?
I want to say I think that's related to a different case.
Oh, okay, I'm sorry.
Yeah, rehearing I think was a different case.
Do we know when she started the work?
I'm sorry?
Do we know when she started the work?
No, ma'am, I do not.
I mean, if she started last week, it's a question.
We heard it in February.
So it's really not a petition to reconsider, even though it says that at the top, Mr. Trask?
That's what she's treating it as. The way I read it, though, she's really asking for more time for compliance.
So with the 30-day requirement that you read from the law, this doesn't apply anyway.
So we haven't gotten that information yet from the Code Enforcement Department. Maybe they could tell us when was the order entered on this case, telling her to come into compliance by May 23rd?
Okay. Hold on a second. What? She made the request in a timely manner. If, she made the request within 30 days of the affidavit of noncompliance.
Okay.
There you go.
I don't know the date the board order was entered. It's not attached to my case yet.
If we gave her more time, will the fine still continue?
So the answer to the question is that if the compliance date is moved, then basically that fine goes away because you've reestablished the date. So anything that is incurred would not have been incurred. So change the date 30 days down the road, and she comes in compliance within the next 30 days, there's no fine.
Have you been out there to see if work has been done?
I'm sorry?
Have you seen if work has been done?
I haven't been out there, honestly. I just haven't been up Chesapeake lately.
I know it's a little street. You don't go down there
Yeah.
much. I know the roofers are busy. I hate to fine her for that.
So those are your 3 options that I mentioned earlier. Deny it, grant it, if you grant it, set a date, or change the compliance date.
If we change the compliance date, all fines incurred to this point would go.
Correct.
This case.
On this case only, right.
Okay, I would guess we try to get people in compliance. We're trying not to be punitive. So my first instinct would be to give her a little more time on
Yeah.
this case.
Yes.
I would say
She
that.
formally
agree.
requested
Yeah, I
within the
agree.
Yes.
designated time.
Yeah.
Yeah.
Is there an official thing to you?
There's no official motion form in your packet there.
Okay.
It would be something similar that I move that the compliance date in case number 18, and then just read all the numbers.
Be extended to?
Be extended to, and then set
Okay.
another date.
And that'll still eliminate any fines.
It eliminates
this
any
case.
fines because the compliance date has now gone away. The May 23rd compliance date would have gone away, and we've got a new compliance date. That's correct.
So the
That's-
fines start on the new compliance date?
Correct. Correct.
So she's had 3 months at this point and used them up.
Actually, since February,
That's 6.
March, April, May, June, July, August, 6 months.
6 months, yeah, not
And
3.
used them up.
The fine just started after 3 months. I think we gave her 3 months.
The
Nothing
fine started
happened.
May 23rd, I
So
think.
she's been
23rd.
being fined since then.
I'll entertain a motion.
Well, she's had all that time and hasn't made the dates. Maybe give her another 30 days, maybe 60 days.
I was thinking 30, September
I
4th.
wouldn't go more than 30, frankly.
I mean, I'm not so concerned about the past fine as I am. She needs time to get this done, and maybe only 30 days is pushing a little bit, but
I think maybe a little gentle nudge might
yeah.
not be a
Well,
bad thing.
that's what I think 30 days is a nudge, yeah.
Yeah.
Is that your motion?
No, not yet, we're still discussing.
Trying to
Yeah,
get
you
to
wanna
when
go
Mr.
home, I know,
What
okay.
I want to do is I want to get a motion on the floor so that you can discuss the
I make a
motion.
motion that we give this case 18800000869 until September 10th.
Yeah.
To come into compliance.
To come into compliance,
Okay,
correct.
There's your motion.
I second?
Okay?
Second.
Discussion.
Any discussion?
I think it's fair.
No, that's 30 days, or a little more than 30 days, you can.
Will there, excuse me, sorry, will there be a fine amount attached to this?
It's the same order as before.
Oh,
It's
very good.
basically just an amendment to the prior order, amending the compliance date to September the 10th.
Okay, thank
It's going to be exactly the same. So
Gotcha.
your prior fine amount would be the same. Everything exactly the same. We're just changing one thing on your prior order.
Okay, sir.
Just for information, do we know what that fine amount was?
I don't. Do we?
I do. Is $100 a day.
That was in that month.
So we
You
would
can do a
follow.
roll call or voice vote.
Let's do a roll call. Motion on the floor is to extend to September the 10th.
Okay. Mrs. Telliar?
Yes.
Mrs. Norfleet?
Yes.
Mr. Robinson?
No.
Mr. Kramer?
Yes,
Mrs. Dabbs?
No.
Mrs. Wade?
Yes.
Mr. Weeks?
Yes.
Motion carries.
Okay.
We have a few household things that we need to do. Approval of the minutes from June the 13th and July the 11th.
I move that we approve the previous minutes from July 13th, or June 13th and July 11th of 2019.
second.
All those in favor say aye.
Aye.
Aye. Opposed, same sign. Motion carries. Any public comments? All right.
Come on down here, Mr. Patzelitis. Please don't talk about any of your cases. Okay.
Like to make some suggestions to the process. Both. I would suggest that when the code enforcement officer submits the notice of violation, that they also submit the evidence along with that, so that the person can see what needs to be done. normally, at least the times that I've come here, the only time I see those pictures is right before the code board, and you really don't have time to evaluate them or look at all the evidence and the documentation to evaluate it to be able to put on a proper defense. And I think that if they can send out the letters and they can post signs on the property, they ought to be able to send the evidence along with the notice of violation that they're using to base the violation. 2, it appears that when violations occur for the same thing, there's always 2 charges, 8-40 and 8-52. That's like double jeopardy for the same violation. I don't know if that's proper or not. I just raised that because if you're going to violate somebody, you might as well violate them for the right violation. Why do you have to pile it on? 3rd, I would also suggest that as part of the equipment of the code enforcement officer, since you have many, many cases that I've observed that deal with overgrown lawns and grass, that the code enforcement officer have a measuring stick of some type to be able to put it down next to the sidewalk to document that the grass is over 12 inches. Because all the pictures that I've seen, you can't tell. There's no way to tell whether it's 6 inches, 8 inches, 4 inches, 10 inches, or more. So that would help you in making your decisions. And so I'd like to submit those items for your consideration.
Thank you.
I have a comment about what's going on in reference to safety of ourselves and the people that come in. I don't know what we need, but I'd like to make sure that we continue to have a safe environment in order to do our job here.
But we're not talking to the audience. So I guess the real question then is it a possibility that we have a police officer be in the audience similar to what we have in commission meetings?
Yeah, Sergeant Fogno just couldn't be here, or do you want are you contending maybe the same circumstances like the BOCs? You know, they're a little different status when they're in here.
So if it was me and all the cities that I represent in the county and so forth, it's always a uniformed police officer, because that seems to be the thing that threatens people off versus being there to catch them once they did it undercover. Right. So
and
that's my
normally
opinion.
Sergeant Fogno or somebody is here. He just couldn't make it. There's just a lot of stuff going on in the police department right now, so we're a little short on a couple of things. So, and then other than me, you know, and I have most of you weren't here a few years ago. I had to stand up and deal with somebody in here. So I completely respect that, and I will pass that on to my supervisor, Sergeant Fogno. And like I said, normally there is one here. He just couldn't make it this month. So, and we'll make it a point. We'll pass it on to try to make sure there is somebody here.
Appreciate it.
It's a good point, really good point. You never know what's going to happen. And no offense to Officer Gasson, because he's the biggest guy in the room, but he doesn't have eyes in the back of his head, and he doesn't see what's coming down the hallway behind him. And so something could happen to him before it happens to us.
Right.
So having the police officer somewhere up in the back is going to be a lot safer.
Yeah, definitely.
So.
Too bad we have to think about that.
Yeah, well.
Good night. It's the name of the game right now. Okay.
I move we adjourn.
Okay. Motion accepted. We're done.
Thank you.
Thanks for all your help today, ladies and gentlemen.